Wait, please, your lordship. Now, the consent of the other side, I beg to mention item number 11, my lord. This matter may be taken after 2 weeks, my lord, if otherwise not inconvenient.
My lord,
Yes.
I am for the appeal.
Heard
Oh,
Mr.
six.
B. Sharma, learned standing counsel, NF Railway, who prays for an adjournment on the ground of personal difficulty. Also heard Mr. J. Mullah, learned counsel for the appellant, who does not raise any objection to the prayer. Hence, the prayer is allowed.
My lord, just a minute kindly. Last date when the matter was listed, they prayed for adjournment, they took, we did not object. Today also we are not objecting, my lord, but only we are compensation matter, appellant is suffering. So my lord, one date may kindly be taken.
4th or 6th of August.
One date may.
6th of August.
Much obliged.
May I please, your lordship, on the consent of the other side, lordship, I beg to mention item number 13 and 14, lordship.
What is your name?
M. Hussain on behalf of S. Hussain.
Heard Mr. M. Hussain, submitting on behalf of Mr. Heard Mr. M. Hussain submitting on behalf of Mr. S. Hussain, learned counsel for respondent number 2.1 and 2.2, who prays for an adjournment. He submits that he has informed learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
May please, your lordship. Lordship, I am praying for listing, lordship. Lordship, matter lordship pertaining to lordship. I am for the lordship claimant, lordship. Matter was posted in the year lordship 2025, lordship.
Listing of
Lordship.
in which column?
I am for the claimant listing in hearing, lordship.
Hearing listing, not by
In
mentioning.
lordship, and on any date as
No,
lordship.
not by mentioning. Pray before registry. Hearing, you pray before registry.
Your lordship, with regards to item number 24, we filed an additional affidavit yesterday, so I would pray that it may be brought on record. Also, another prayer, your lordship, for listing of orders for an FOA matter.
24 June.
Much obliged.
May it please your lordship, I beg to mention item number 22. Kindly adjourn the matter for 3 weeks. We have taken the consent of the other side.
Third, Ms. D. Goswami, learned counsel for the appellant, who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the appellant. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Obliged, lordship.
May it please, your lordship, I beg to mention item number 29 to 32. My lord, there is certain personal difficulty of my learned senior friend and as well as me, my lord, joint prayer. Can it be taken up on after 15th August, my lord?
Heard Mr. D. Rathi, learned counsel for the appellant. Item number 29 to
32, my lords.
appellant, who prays for an adjournment on the ground of personal difficulties. Stop. Also, Mr. B. Sharma, learned standing counsel NF Railway, who does not raise any objection to the said prayer. We are not giving any fixed date. After 4 weeks,
My lord, fine.
the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
Much obliged. My lord, I beg to mention listing of 2 MFs as well in the order section, my lord. If any date can be granted, please.
27 July.
Much obliged.
May please, your lordship. I pray for listing in order columns, your lordship. Interlocutory application.
29th.
So about
Please, your lordship, item number, I beg to mention item number 34 of supplementary list. Matter may be adjourned for today.
You have informed the other side.
And for appearing for opposite party.
You have informed the appellant Have you informed? No.
Yes, Your Lordship.
You have informed.
Yes.
What is your name?
SK Begum.
Heard Miss S.K. Begum, learned counsel for the respondent. For whom you are appearing?
Oriental Insurance
Your
Company.
name is not there in the cause list. You are engaged counsel or you are appearing
Sir M. Chaudhary.
appearing on behalf of Miss M. Chaudhary, seeks an adjournment. She submits that she has informed learned counsel for the appellant regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
We missed the matter, Lordship, my first.
Okay, 4 weeks.
May I please, Lordship? Lordship, pray for listing one IA, Lordship, MFA. IA for condemnation of delay, Lordship, 22-7, Lordship.
Orders.
Orders.
May I please, Your Lordship?
Yes.
My lord, this is the fourth round of litigation, my lord. Earlier, 3 applications your lordship rejected at this stage, my lord. And my lord, the co-accused Joynal Haq, who has been released on bail by your lordship in the earlier order. Now, my lord, I am before your lordship on the new grounds, the grounds of delay of trial. Today, my lord, 1 year, 7 months, 22 days. And my lord, no witness has been examined yet. So, my lord, the grounds, my lord, I have explained. Page 8, my lord, para 11 and 12, and page 10, para 15. Although, my lord, para 11, the grounds which I have contained, that was earlier raised also in the last bail application. However, your lordship is not.
Where is the last rejection order?
Last rejection order, my lord, page 66, my lord. Page 66 to 70.
How many days you are behind the bars?
Now, my lord, 1 year, 7 months, 22 days.
Your Lordship, I want to humbly submit, Your Lordship, in my submission, the incriminating materials against this petitioner. What had happened, Lordship? First, Lordship, Joynal. From him, Lordship, 2.19 kg of methamphetamine has been found of Uva tablets, which the commercial quantity is only 50 grams, Lordship. And he has indicated to this person's house, Lordship, this present petitioner, and in his house also, kitchen, Lordship, it is found 0.98 gram, 98 kg. That means 980 gram, Lordship. So commercial quantity comes from his house also, Lordship. So it is a 37.
That submission is wrong, my lord. From Joynal Haq, it is recovered 2.191 kg.
Yeah, but from his present
And
petitioner.
present
his store-
petitioners, my lord, from my home, my lord, I was not present.
That means-
Let him
My,
That is a different case, Lordship. He is present or not. But in his rented house, Lordship, his wife is there. And in that house, Lordship, 0.98 gram. I have also, and
0.98 gram.
0.98
kg.
980 grams, Lordship. Where the commercial quantity is 50 gram, Lordship.
That is 980
80
grams.
grams, Lordship. That is also a commercial quantity, Lordship. It is not that a co-accused has stated him, Lordship. In his house also, possession has been found.
Where is the bail order of the co-accused?
Co-accused, my lord. Page 48, my lord. Page 48.
When the co-accused was arrested,
Co-accused, my lord, arrested on that date, my lord, on 22/8/2023.
same day.
Same day, no. I was, my lord, subsequently, because I was not at home, my lord. Subsequently, I was arrested, my lord. I was arrested, my lord, on,
5/12.
after issuing NBWA, my lord. Not by
On the
police.
strength of NBWA.
On the strength of NBWA,
5/12/2024.
on 5/12/2024, my lord.
At what stage trial is pending now?
Trial is no witness examined, charge is framed, my lord.
Lordship, on the last date is 11/6/2026, and it is fixed. The next date is 9/7/2026 for evidence.
When the charges were framed,
I'll just framed on. Lordship, 28/2/2025. Is it correct? Okay.
how many witnesses are there?
9 witnesses are there.
9 witnesses, my lord.
2012.
Mr. H.
Yeah, madam, I would like to place one recent judgment just, I would like to, your lordship.
I heard Mr. H.
Lordship, I apologize. 2012.
20.
28/2/2025. It is in the order sheet, Lordship.
Heard Mr. H.R. Chaudhary, the learned counsel for the appellant, learned counsel for the petitioner. Also heard Mr. K.K. Das, the learned additional public prosecutor. This application under Section 483 of BNSS, 2023 has been filed by the petitioner Jamal Hussain, seeking his bail in connection with special NDPS case number 109/2023, pending in the court of Learned Session Judge Sri Bhumi, arising out of Karimganj PS case number 627/2023 under section 22C/29 of the NDPS Act 1985. Stop. The petitioner has been detained behind the bars since 5/12/2024 within bracket for last 1 year, 7 months and 22 days bracket close. It is pertinent to mention herein that before filing the instant bail application, the petitioner had approached this court on 3 occasions seeking bail. However, the prayer for bail was rejected on all the 3 occasions. This time, the petitioner has approached this court on the ground of prolonged incarceration, as one of the co-accused has also been granted bail by this court on the ground of prolonged incarceration. The gist of accusation in this case is Court Para 4 from page 67, Court Para 5 from page 67. The learned counsel for the petitioner has submitted that Mr. H.R. Chaudhary, the learned counsel for the petitioner, has submitted that the petitioner has been languishing behind the bars for last 1 year, 7 months, 22 days, and the examination of prosecution witness is yet to commence. He submits that though the charges were framed on 28/2/2025. However, till date, not even a single witness out of 9 enlisted prosecution witnesses have been examined. He further submits that in the meanwhile, one of the co-accused, namely Joinal Haq. What is your name?
My name is Jamal Hussain.
Joinal Haq has already been granted bail by this court on 3/3/2025 in bail application number 3831/2024 on the ground of prolonged incarceration after he had completed more than 1 year, 6 months of detention. Learned counsel for the petitioner submits that the present petitioner has completed more time behind the bars than that of the co-accused who was released on bail on the ground of prolonged incarceration. Hence, he submits that the prolonged incarceration of the petitioner has infringed his fundamental rights guaranteed to him under Article 21 of the Constitution of India. And as such, same outweighs the embargo of Section 37 of the NDPS Act 1987. And on that ground, he submits that the petitioner is entitled to get bail. In support of his submission, Code Para 6 from page 50 of the. On the other hand, Mr. K.K. Das, learned additional public prosecutor, has vehemently opposed the grant of bail to the present petitioner on the ground that the contraband seized even from the residence of rented premises of the present petitioner is of commercial quantity, that is 918 grams of methamphetamine, 980 grams of methamphetamine tablets. Hence, he submits that the embargo of Section 37 of the NDPS Act is applicable to this case. He further submits that the present petitioner was evading the arrest and he had to be arrested only after issuance of non-bailable warrant of arrest against him. I have considered the submissions made by learned counsel for both sides and have gone through the records of scanned copy of the case records of special NDPS case number 109/2023, which was requisitioned in connection with this case. Code Para 1011 from page 51. Page 13. Next para. In the instant case, the petitioner has been languishing behind the bars for last 1 year, 7 months, 22 days, and not even a single prosecution witness has been examined till date. Hence, the prospect of early culmination of trial is very bleak. Code para 15 from page 53. 16 from page 53. 17 from page 53.
My lord, petitioner in fact is a very poor person. He was in a Aizol for a, my lord. If your lordship is desired to, my lord, some leniency in this regard of conditions, my lord, I will be grateful to your lordship.
No leniency.
He can buy lordship 980
condition,
grams of a methamphetamine, but he has no money lordship.
I am a my daily worker, wage worker at Aizol, my I was at Aizol.
You are getting bail in a commercial quantity of contraband. That is the leniency. 2 lakhs with 2 sureties of like amount.
Order.
Please, your lordship. In this case, I'm appearing for respond number 1.
Item number? Yes. No one has appeared for this. Oh, you are for the
Respond number 1.
respondent.
It's order dated 5/6/26, lordship. The appellant was directed to take steps by Dusty, lordship, upon 54.
None has appeared for the appellant when the matter was called. Ms. M. Chaudhary, the learned counsel for the respondent number 1 is present. It appears that on 5/6/2026, the appellant was directed to take steps for issuance of notice upon respondent number 2 to 4 by Dusty Mode and thereafter file an affidavit in compliance thereto. However, as no one is present on behalf of the no one is present for the appellant, let this matter be listed after 2 weeks on a date to be fixed by registry.
Supplies, lordship.
Item 4.
May it please your lordship. My lord, in compliance with the order dated, my lord, 8/5/26. Dusty service has been taken, my lord, and dusty affidavit has been filed, but that is not tagged with the record, my lord. Let it come in the next week, my lord.
Okay. Heard Mr. T. Kolita, learned counsel for the appellant, who submits that though in compliance to the order dated 12/6/2026, the appellant has filed an affidavit, not 12/6, 8/5/2026. The appellant has filed an affidavit in compliance of effecting service on respondent number 2 by Dusty Mode. However, the said affidavit is not tagged with the records. He prays for directing the registry to tag the affidavit filed by the appellant and list this matter after a week.
My lord, date may be fixed, my lord.
The prayer is allowed. Let this matter be listed 3rd of August.
My lord, in the meantime, my lord, interim may continue, my lord. Passed in 3/2/6/4/25.
In the meanwhile, the
I 3/2/6/4/25.
interim relief granted, interim stay granted in connected interlocutory application number
6/4/25.
3264/2024 shall continue till next day.
Hello.
May I please, Lord?
Yes.
My lord, before he begins, we have recently entered appearance, my lord, in this matter. And there are some instructions to be obtained from the respondent here because we have not received a trial court record from the respondent. And it was called for today also.
How many respondents are there?
Sole respondent.
Sole
respondent. So regarding the probate order that was issued in my favor.
Whether records have arrived. Heard Mr. T.R. Gogoi, the learned counsel for the appellant. Also heard Mr. J. Singh, learned counsel for the sole respondent, who submits that he has been recently engaged by the respondent to appear in this appeal, and therefore he seeks some time to take some necessary instruction in this regards. And the prayer is allowed. It appears that the trial court records have been received, and therefore this matter is ready for hearing. Accordingly, let this matter be listed for hearing on 13th of October.
Gotcha.
Good to go.
On.
Interim application also on the ISC bill for stay of the judgment, my lord.
Well, it can be all taken up together at one date only. This is against.
What stay?
My lord, stay of the, my lord, the order passed by the, my lord, the district judge, my lord, granting of probate, my.
My lord, we are already in the possession of the property and.
That's a different issue, my lord. Either possession or that's a different issue. It's not, probate case nothing to do with the possession. It's not for declaration of right
No,
title.
how stay is urgent?
My lord.
Why stay is urgent? What is the urgency of this?
My lord, they may go for, my lord, the
What?
execution,
What execution?
my lord, of this order.
What they will do?
I think, my lord.
You explain to me. If there is any danger.
So they may go for the, my lord, the mutation, and they may go for the land is also involved, my lord, there.
They are in possession.
Yeah. We are in the possession board.
No, no.
So therefore, my lord, status quo as on date may be mentioned. We are also, my lord, doing there. They are also my lord. Both
It
them,
is a
my
big
lord.
land.
That's maybe.
That is what I have
Yes,
understood
my
from the
lord.
news. It's a big land. They have already been staying on some part of the land.
Yes, yes.
The one in which we are in possession, that's the
Therefore,
RCC
my
building.
lord, yes. My lord.
So that is already there. And with regard to the probate order that
Yeah.
has been passed, no law says that the respective titles will not be conferred to us.
Because I, as part the will, my lord,
My lord, in
there is
any
no
occasion, if
bifurcation
I
of the land.
proceed to do anything that is a third party rights or maybe get a mutation,
Yes.
it will be pursuant to the order passed of this honorable court.
No, no,
So anyways, my lord, if on 13th October this matter will be
because
taken
the
up
order
finally,
is in their favor. That's a problem, my lord.
my lord,
The status quo by both
it
the
is an
parties, my
order
lord. I am
after hearing
clearly
of 11
submitting.
Status quo means no stay.
My, whatever the position as on date, my lord, that should be maintained, my lord. That is I am praying for.
No, in order 41 rule 5 application.
Yes, yes, yes. my
How
lord.
status quo?
My lord, it cannot.
It will be decided on next day
Yes, my lord.
along with the application.
Well, there should not be any, they should not take any prejudice to the appellant, my lord. That is
What
only,
prejudice?
my lord.
What prejudice? You have to specifically mention.
That is why, my lord, because the, as per the will, the land has been, my lord, they alienated in their favor. Now, we are also the paying on the some part of the land, my lord. Now, by virtue of this order, they may ousted us, my lord, from the
Then
land.
you come to this court seeking, filing appropriate application.
That observation may kindly be made, my lord, if in that case, my
No,
lord,
no,
that was
no
my
observation.
lord.
ISM.
We have made categorically mentioned, my lord. Yes, paragraph 12, we have said, my lord.
What they will do in by executing the in whose name land is mutated now?
My lord, it stands in mind.
In
No,
As
no.
because there was a probate order, and after the probate
Yeah,
order,
yeah.
it was supposed to be done in mutation in my name.
Yeah.
But there's a cooling off period in which they have approached this honorable court.
Yes, yes.
And since that matter
Now
is
it has
pending
come
now,
out, my lord. Now it has come out. They are going to
No,
mute.
let them submit.
point that they filed in case nothing could adverse happen from my
Yes.
side. So on 13th October, if it could be heard on finality, this stay order would not be required to be passed today, my lord.
It will take too long, my lord.
And anyways, this probate order can only be challenged on the point of will. There is nothing with regard to partition, demarcation, or anything apart from the
Not-
land. So that submission, I don't understand why.
Yes, probate order is only with respect to the
Will.
genuinity of the
Yes,
genuineness of the will.
Yes. Now, what is the further, my lord? Suppose a probate has been granted, my lord.
Yes.
On the basis of the probate, they go for mutation of the land. Tomorrow they sell the land also, my lord. That is why I am submitting, my lord.
If
So
they,
That is the,
if-
my lord, the
Evidence
best.
for that,
Yes.
that cannot be challenged before this
there
honorable
is
court
a
unless the-
different, you can approach this court by filing appropriate application under that. Now only statement is that will is genuine.
My lord,
Probate may
no
be
further proceeding on the basis of the will. That is why I am asking for, my lord. So there no further proceeding.
That relief cannot be granted under 41.5, under order 41.5. For that, you have to file an appropriate application. Under 41.5, only execution
Well, if I,
has, yes.
if he thinks 13 October is too far, I may pray that some early date also may granted for his convenience if he believes that. Otherwise, my lord, in this matter, there is no stay order that can be operated. The sole ground that they've raised is suspicion before the trial courts. If that has to be made out here, then my lord, a elongated hearing of all the PW's depositions has to be observed.
I'm a widowed lady, my lord. And I am the natural heir of the, my lord, the testator.
Even if stay is granted, it will also not make any difference to you.
Yes.
My lord, the filing of this case.
Why is afraid, I don't know. My lord, why is afraid, I don't know.
Filing of this case.
Heard Mr. B.J. Ghosh, learned counsel for the applicant. Also heard Mr. J. Singh, learned counsel for the respondent, who submits that he has been newly engaged by the respondent and requires some necessary instructions to be obtained before he makes his submission in this interlocutory application. And as such, prays for some more time. The prayer is allowed. Let this matter be listed along with the connected appeal on October, 13th of October. Till that date, the execution of the impugned judgment shall remain stayed. List accordingly.
My lord, as per last order, the registry has submitted postal receipt in the record. And notice to the OP number 1 is completed, my lord.
How many respondents?
Sole respondent, my lord.
Who is the respondent? Insurance company.
Yes, my lord.
Which insurance company?
Oriental Insurance.
Someone may appear for, or we'll fix one more date.
Okay, my lord. 7th
Um,
best.
Heard Mr. B.R. Das, learned counsel for the petitioners. Office note dated 13/7/2026 shows that from the postal track consignment report of the notice sent to the sole respondent by speed post, it appears that the notice was delivered to the sole respondent on 8/5/2026. As such, the notice is held to be duly served on the sole respondent. However, one more chance is granted to the respondent to appear in this review in this case. Hence, let this matter be listed again on 7th of August.
Yeah.
Please, your lordship. Your Lordship, kindly pass over the case for the time being. The engaged counsel is in another matter at the moment.
What is the matter?
If I may, my lord, the I is for injunction, my lord. My lord, the matter pertains to an FAO, stemming out of an order passed by the Honorable Civil Judge number 1, wherein the injunction application was denied. My lord, the trial court records have been received by this honorable court. My lord, a date may be fixed wherein the
For final hearing.
yes, my lord.
Okay. Heard Mr. G. Imtiaz, learned counsel for the applicant. Also, heard. What is your name?
Kotsu, Your Lord.
S.
Kotsu,
Kochu, appearing for
P. Chakraborty. Your Lordship,
Miss P.
she's on her way.
Miss P. Chakravarti, learned counsel for respondent number 1, 2, 3, and 4. Also, heard Mr. T. R. Gogoi, appearing for respondent number 1, 2, and 6. It appears that the records of the scan 2 and 6. Putul, how to do appeal? It appears that the scanned copy of the trial court records have been received. Hence, this matter may be heard for final disposal. Accordingly, let this matter be listed on
My lord, on 23rd, if possible, my lord, because
20
some urgency is there in this matter.
23rd.
Of July, my lord.
It will be difficult. No, August first week or first or second week. 4th of August.
Deeply obliged.
Let this matter be listed on 4th of August.
My lordship.
Yes.
This appeal, my lord, relates to a rejection against rejection order of my application under order 40, my lord, of
Order?
appointment of receiver.
Order 40.
Yes, my lord. So today is the first day, my lord. The other all are appeared, my lord. So we have to let the copy to be served on today itself, my lord. We'll serve the copy.
Heard Mr. B. The
Only request, my lord, that to expeditious disposal of this appeal, my lord, this so far is latest appointment of receiver. That's the urgency.
Heard Mr. B. Dutta, learned senior counsel assisted by Mr. S. Deka, learned counsel for the appellant. Also heard Mr. A. K. Gupta, appearing for
Respondent number 1.
respondent number 1A and 1A, as well as Mr. D. Chaudhary, appearing for respondent number 3 and 4. Who is appearing for 2?
2 and 3, in fact, may not proceeded expertly in my IA.
Or notice?
Notice has to be gone, my lord. That's the problem.
3 and 4. This
2 and 3, ne? 2 and 3. 2 and 3. Huh? 3, 2, 3, 4? 3, 4 here. So 2 can.
this
2, my lord.
this appeal under order 43 rule 1 within brackets small s of the Code of Civil Procedure 1908 has been preferred by the appellant Shri Rajesh Shukla, impugning the order dated 13/2/2024 passed by the Court of Learned Senior Civil Judge Senior Division Tinisukia in Ms. case number 85/2020 arising out of title suit number 27/2020, whereby the prayer of the present appellant for appointment of receiver for administration of estate of Shri K. Ram Keval Shukla in respect of suit property was rejected. Let the notice be issued to the respondents. Since Mr. A.K. Gupta has already appeared for respondent number 1A and Mr. D. Chaudhary has appeared for respondent number 3 and 4, no formal notice need to be issued to them. However, the appellant shall furnish requisite numbers of copies of the memo of appeal along with the annexures to the learned counsel for the said respondents. As regards respondent number 2 is concerned, the appellant shall take steps for issuance of notice to the said respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th August. Whether records would be necessary.
Since the hearing is to be on the next part, so record may be called for. In this case, 85.
Let the records of Ms. J case number 85/2020 and scanned copy of the
Scan copy is a disposed record, my lord. Is having called for.
scanned copy of the record of original copy of record of
Yes,
Ms. J case
disposed.
and scanned copy of the title suit number records of title suit number. Whether title suit is also this.
Required, my lord, not. Because all the requisite annexures are there.
Okay. Records of Ms. J case number 85/2020 arising out of title suit number 27/2020 be called for from the trial court. Registry to take steps for requisitioning the records. List accordingly.
My lord. Grateful.
Name is not reflected in the court list.
Name of Mr. A.K. Gupta may be reflected in the cause list as engaged counsel for respondent number 1A henceforth.
Mr. Dagger's name also not reflected by assisting counsel.
Mr. Similarly, the name of Mr. S. Deka may be reflected in the cause list as the
Counsel for the paper.
counsel for the appellant henceforth.
Grateful, man.
May I please? There is an MSc appeal by insurance company.
Mr. A. Bhattacharya, learned counsel for the appellant. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant, namely Cholamandal MS General Insurance Company Limited, impugning the judgment and order dated 13 judgment. Award was granted.
Yes.
Judgment and award dated 13/3/2026 passed by the court of London District Judge.
Additional district judge.
Additional District Judge FTC Dorong / member MACT in MAC within bracket D case number 9/2022, whereby the present appellant was directed to pay a compensation amount of rupees 39,42,000 along with an interest at the rate of 6% per annum to the respondent claimant. I have gone through the grounds stated in the memo of appeal and considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MACD case number 9/2022 be called for from the concerned tribunal. Registry to take steps for requisitioning the records. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice to both the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th August. List accordingly.
There is a I for stay also, 2146 of
Will
26.
you pay 50%?
My lord, I'll be paying 25%.
Then
Here,
we'll issue notice.
my lord, why I'm submitting, my lord?
No,
The
no submission. We are issuing notice. Let the other side come. Then we will grant stay. In IA,
Then your lordship,
if you pay 50%, I will grant stay immediately. Otherwise, not.
regarding release, we will see later on. My lord. Lordship will be only directing us to deposit only.
Yes. Heard Mr. A. Bhattacharya, learned counsel for the applicant/appellant. This interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure 1908 has been filed by the applicant insurance company in connection with MAC Appeal number 329/2026, praying for stay of execution of the impugned judgment and award dated 13/3/2026, passed by the Court of London Additional District Judge FTC in MACD case number 9/2022. Let the notice be issued to the respondent. The applicant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th August. Stop. In the meanwhile, since the connected appeal has been admitted, the operation of the execution of the impugned judgment and award shall remain stayed till next returnable date, subject to deposit of 50% of the awarded amount by the insurance company before the registry of this court, before the next date fixed. List accordingly.
Like,
I have already heard this matter.
Yes.
You have to submit the written gist.
After some time, melody, discuss you will say, after some time.
You will be submitting.
It's better to take time for the time being, melody. He's in court 6, melody.
No, whether he will be submitting any written gist.
He said that he will come in, melody.
That pleasure. Your lordship, by the order dated, my lord. And 6, that is 26, my lord. Both the parties were requested by this home court to submit detailed synopsis. But accordingly, I have submitted, my lord.
Okay. Let him come. I will reserve this matter. Let him
If they
come.
attest, my lord, they were fine.
After some time.
I'll take it up after some time. He has come already. You are submitting any written gist?
I have to file this, there was some development as means, because there was one issue I have been instructed, because though I had already argued, there was one issue, if your lordship recollects, that with regard to the executive engineers does not have the power, which was the issue by which the termination was held to be bad. But those issues, as I had argued earlier, was not framed while arguing at the trial court. My learned colleague also took the plea that this is a thing, but there was no pleading as such. Now, 2 documents have been given. I will seek your lordship's consent because these 2 documents were filed. page 5. There are two documents which has been handed over. I was not the counsel in the trial court. Two documents have been handed over by the department to me. I have been just, I have not given this, the Lordship may just have a look into it, Your Lordship. These documents, Your Lordship may kindly see, I have been handed over yesterday. These documents, I think I need to place before Your Lordship while submitting my written argument by filing an application under 4127, Your Lordship, subject to my colleagues' thing, because this is an issue was not framed earlier, but it appears that these two documents might be relevant. I will give a copy to him also.
No, you want to say that you want to file an application.
Additional evidence beyond the
Yeah.
pleadings, beyond the
No,
evidence
because
declared before
it was
the
not
trial
the
court.
pleading also, because they were the plaintiffs.
Now, today, what is your prayer?
My prayer, because I have been just, I have gone through it. I was preparing the argument, it was handed over. So I felt to apprise this court about this before making my submissions before this, because
Now, what is your prayer?
my prayer is, Your Lordship, I may be allowed to file this document through appropriate application under Order 41, Rule 27, if Your Lordship permits. Because
Objecting the same.
this might be essential, because I was also totally in the dark. I had not come across this document earlier. Because maybe because there was no issue framed with regard to the power of the executive engineer terminating the contract was not an issue out there. Though termination, general issue was there, whether the termination was
Hello, issue number 3 covers his submission, my lord. Your Lordship, I can
means,
see issue number 3
that is
covers
the
all
one
the
issue
submission.
which I will not dispute. There was an issue, whether the
No.
termination was bad, but there was no pleading.
No, if you want to file any application under Order 41, Rule 27,
Yes, Your Worship.
you should have filed it.
That's why I am not saying that I was handed over this recently.
I don't.
Because
Okay.
I was there. That
Okay,
is
I
why
have
I could
heard.
not.
Now, what is your prayer?
I seek a leave, Your Lordship. If Your Lordship allows, I will file. Otherwise, I will file with the written argument within 1 week, Your Lordship.
You are seeking time for filing
written argument, or if Your Lordship allows filing this application, because these documents might be necessary, Your Lordship.
No, for filing Order 41, Rule 27 petition, whether leave of the court is required.
No, not required, but as it is fixed at this juncture.
You could have filed it.
I have received it
even
yesterday.
today. It would be decided on its own merit whether to allow it or not.
No, then a short accommodation may be given to.
We may give you time for filing written gist of written submission. Remaining, if you want to file any objection, they will have
time may be given.
right to object.
No, he has the right to object. I won't dispute.
Heard Mr. A. Bishwas, learned counsel for the appellant. Also heard Mr. N. Alam, learned counsel for the respondent. In pursuant to the order dated 9/6/2026, the learned counsel for the respondent has filed his written gist of argument along with the rulings relied on by him. However, Mr. A. Bishwas, learned counsel for the appellants, has submitted that some new document has been traced out by the
department,
by the
appellant.
And the appellant may appellant may have to file some application bringing on record said documents. However, today He also submits that his written gist of argument as was directed by this court by its last order is not ready and seeks a week's time to file the written gist of argument. The prayer is allowed.
Next Thursday, your lordship.
Let this matter be listed again on next Thursday,
Next Thursday.
20, on 23rd July for filing written gist of argument. You can take back this.
Yes,
You
I have been receiving this, so I
list accordingly. If you are filing any application, you have to give advance copy to the other
Yes, yes.
side so that they can
They
object,
have the opportunity to place on the.
list accordingly on 23rd.
Obliged, your lordship.
No, into record of document. This we are making part of record.
Item 10.
Appealing for response number 7.
Claimant is not.
Who is for the claimant?
Mr. S. Ahmed was there, lordship.
What is to be done? Claimant would be required.
Next day.
Ex parte.
Yes. Wait, no.
Heard Mr. A.J. Saikia. Heard Mr. A.J. Saikia, learned counsel for the appellant. Also heard Ms. M. Chaudhary, learned counsel for respondent number 7. However, when the matter was called on for hearing, no one appeared for the claimants / this respondent number
1 and 2.
Respondent number 1 and 2. Stop. It appears on perusal of the record that on last date also, that is on 22/5/2026, when the matter was called on for hearing, no one appeared for the claimant. Stop. One more chance is granted to the claimant side. Hence, let this matter be listed on 4th of August.
Obliged.
May please no. Madam, password for the time being, my senior is in another.
After some time.
Correct, sir, my lord. My lord, in
Who
the
is for the other side?
other side, my lord, in the cause list, the name of the opposite party is not reflected, advocate for the. Usually, my lord, I know the concerned advocate, and he's saying today that that matter may be fixed on another date because his name is not reflected and he is not prepared.
What is the, who was appearing?
Assistant Government of Arunachal Pradesh Advocate A.N. Das. Arun Chandran, my lord. Arun Chandran.
Heard Mr. B. as learned counsel for the appellant. No one has appeared for the respondent side. It appears that in the causeless, name of the counsel for the respondent is not reflected. It also appears that on 6/9/2024, a direction was given by this court to the registry to reflect the name of the counsel of the respondent side in the cause list. However, same is not done. Registry to comply with the said order and name of the counsel for the respondent within bracket Mr. A. Chandran, the learned additional senior government advocate Arunachal Pradesh be reflected in the cause list henceforth. Let this matter be listed 7th of August.
I'm going to respond, Lordship.
Who is for the appellant?
Yeah, but that's I think was appearing. A long pending case, Lordship, which since 2024, this case is pending in hearing.
Now what is to be done? Appellant is not there.
Let what for some time. I'll try.
We'll take it up after some time.
May it pleases your lordship. I'll first read the judgment, lordship, and then I'll show where is the effect. Because while reading itself, lordship will find the effect in the judgment.
Okay.
That starts at page 9 of my memo of appeal, lordship, Annexer 1.
Just a minute.
Yes, lordship.
Yes.
Lordship. The instant claim case has arisen out of a petition filed under Section 166 of Motor Vehicle Act, hereinafter referred to as MV Act, claiming compensation on account of death of Palash Bora, son of the claimant in a motor vehicular accident. The case of the claimant is that on 7/4/2016, while the claimant's son, since deceased, was working in his office at Thingau in Manipur, the offending Tata Hiva. So, Lordship, this will be
Just a minute. Yes.
This will be important, Lordship, the type of
No,
vehicle.
I missed what you have.
Okay, I'll again start, Lordship. The instant claim case has been arising out of a petition filed under Section 166 of the Motor Vehicle Act, herein after referred to as MV Act, claiming compensation on account of death of Palash Bora, son of the claimant, in a motor vehicular accident. The case of the claimant is that on 7/4/2016, while the claimant's son, since deceased, was working in his office at Thingau in Manipur, the offending Tata Hiva, that vehicle, type of vehicle is important, Lordship, because our case is based on this type of vehicle and about the DL. Bearing registration number so-and-so, driven in a rash and negligent manner, broke the wall of the office worksite and knocked down the deceased and other persons present. It is stated that as a result of the accident, deceased sustained grievous injuries on his person and immediately rushed to Silchar Medical College Hospital, where he succumbed to his injuries. A bare reading of the claim petition goes to show that the claimant has asserted that the driver of the offending vehicle was rash and negligent, and as such, they have pleaded the owner of the vehicle being vicariously liable for the act of the driver as opposite party number 1. The driver has been impleaded as opposite party number 2 and the insurer of the vehicle has been made opposite party number 3. Hereinafter referred to as OP number 1, OP number 2 and OP number 3 respectively. Notice was served on these opposite parties number 1 opposite parties. OP number 1 did not contest the case. Lordship, here also in the appeal notices were served, they have not appeared, while OP number 2 and 3 have contested the case by filing written statement. The OP number 3, driver of the offending vehicle, in the written statement contended inter alia that the claim petition is not maintainable against him and that there is no cause of action. The opposite party does not dispute the road traffic accident but pleaded that the deceased was also partly responsible for the accident. Rash and negligent driving has been specifically denied. It is further pleaded that the driver of the vehicle had valid driving license DL number so and so, which is valid up to 27/2020. So, Lordship, this DL is also important for our case. The driver has put forth that the vehicle was insured with Oriental Insurance Company Limited. In that backdrop, OP asserted that in case any liability is fastened upon the owner, then he should be indemnified by the insurer. It need to be placed on record that OP number 1 has not specifically denied the accident. The OP number 2, Oriental Insurance Company Limited, in the written statement contended inter alia that the driver of the vehicle had no valid driving license at the relevant time of accident and hence the company is not liable to indemnify the owner. So this is vital. The company has further pleaded that there was breach of policy. Rash and negligent driving on the part of the driver of the vehicle is also denied. The insurance company further denied the age, income, and occupation of the injured as alleged in the claim petition. The accident had also not been admitted by the insurance company. Upon the pleading of both sides, the following issues were framed for proper adjudication of the case. The issues casted: whether the claim petition is maintainable; 2, whether the accident occurred due to rash and negligent driving of the driver of vehicle number so and so, Tata Hiva; 3, whether the claimant is entitled for compensation and if so, what reliefs the claimant is entitled to; 4, to what amount the claimant is entitled to and who will be liable to pay the amount. Claimant Rupa Bora examined 2 witnesses, including her husband, as eyewitness. Besides the oral testimony of PW1, exhibited a number of documents in support of the claim. The contesting opposite party adduced evidence of 1. Mohim Bhuya and 2. Nitumoni Chaudhary as DW1 and DW2 to rebut the case of the claimant. I have heard argument of learned counsel for claimant and the insurance company. I have studied the evidence on record. For purpose of clarity, I would like to proceed issue-wise. Issue number 1. Claimant impleaded the owner, driver, and the insurer of the offending vehicle as party to the suit. It is also noted that the claimant specifically asserted that accident occurred due to rash and negligent driving of the driver of Tata Hiva. Thus, ingredient of Section 166 MP Act stands fulfilled. I may point out that the burden is always on the contesting opposite party to prove that the tribunal does not have the authority and jurisdiction to take up a claim case. In the case at hand, nothing credible has been shown that would indicate that the cognizance is either expressly or impliedly barred. In any view of the matter, therefore, the issue on maintainability is decided in favor of the claimant. Issue number 2. The question to be now decided is whether driver of the Tata Hiva was rash or negligent. The claimant examined as PW2 Deepak Bora and Dina Bora as an eyewitness, alias Dina Bora as an eyewitness to prove rash and negligent driving. Deepak Bora alias Dina Bora, PW2, averred that on the day of accident, he along with his deceased son were working as supervisor in Creative Consultant and Builders, a private firm under Bharatiya Infra Project Limited, Thingaon, Manipur. It is testified that on 7/4/2016 at about 11:30 a.m., his son was busy working on the computer recording the data of the material carried by the vehicle number so and so. At that time, suddenly the backside dala of the said vehicle fell down due to driver suddenly moving the vehicle backward, and as a result, his son sustained grievous injuries, which ultimately led to his death at Silchar Medical College and Hospital. The insurance company cross-examined this witness. It comes out that the presence of PW2 at the place of occurrence is natural in as much as it is not in dispute that PW2 was working in the same firm at the time of accident. Thus, the evidence of PW2 as regards the manner of accident appears to be credible. To fortify the assertion of rash and negligent driving by the driver of truck, PW1 has brought to my notice that the police case was registered by Nungha PS case number 15416 against the driver, which culminated in a police report, white final report. Lordship, I'll use this final report also for my case, Lordship. Final report number so and so dated 21/2/2019. A careful reading of the final report goes to show that upon investigation, it is concluded that OP number 2 was driving the truck bearing number so and so, and that it hit Palash Bora, leading to his death. The police is of the opinion that the accident occurred due to brake failure. Mechanical defect may be a good defense against criminal prosecution. However, such defense has no plea in a case governed by law of torts. It need to be placed on record that vehicles on road can cause major damage, including loss of precious life. Therefore, it is expected of the owners of the vehicle to keep the vehicle roadworthy. In the case at hand, it is transparent from the police report that the owner had not kept the vehicle in the manner it was expected to, and that is sufficient negligence for purpose of fastening civil liability. In any view of the matter, the claimant has been able to create a preponderance of probability in favor, and hence issue number 2 is decided in affirmative. Issue number 3 and 4, the law with respect to grant of compensation in death cases is well settled. The criteria which are to be taken into consideration for assessing compensation in the case of death are 1. The age of the deceased at the time of the death, 2. The number of dependents left behind by the deceased, and 3. The income of deceased at the time of his death. Reliance placed upon a 3-judge bench of Supreme Court in United India Insurance versus Satinder Kaur. Age of deceased. Deceased was 18 to 19 years old as per the post-mortem report. However, ideally, some credible document like Aadhaar, voter ID, Aadhaar card, voter ID card, etc. ought to have been proved. Since these documents have not been exhibited and since age has a direct correlation with the multiplier, I deem it fit to take a conservative view of the matter and hold that the age of the deceased would be computed in the range of 26 to 30 years, and thereby the multiplier would be reduced by 1. Income. A bare reading of evidence of PW1 and 2 goes to show that the deceased was working in a private firm at Manipur. On that day, this point, there is little cross-examination. However, his income has not been proved. Therefore, this tribunal has treated the deceased as unskilled worker employed in a private firm. To determine the income of such person, this tribunal rely on the principle laid down by a 3-judge bench decision of Honorable Supreme Court in Kirti versus Oriental Insurance Company Limited, reported in so and so. The apex court observed that at the very least, the minimum wage applicable to the state where the deceased was residing ought to be taken as the notional income. Therefore, I have looked into the notification number so and so dated 18th August 2021 issued by citation. Principal Secretary to the Government of Assam, Labour Welfare Department, as per the notification, the minimum wage per month of an unskilled worker, including the variable DNS allowance, has been fixed at rupees 8,946.30. However, the road traffic accident took place in 2016, and the rate applicable at that time is not available. In absence of notification relevant to that period and having regard to the present rate, which is almost 9,000, this tribunal deems it fit to hold that the monthly income of an unskilled worker working in a private firm in 2016 would be around 7,500. Deduction of income. In case of bachelor, 50% of his income should be deducted towards his personal and living expenses. In the instant case, the deceased was a bachelor. Hence, 50% of the income of deceased has to be deducted from his annual income for the purpose of computing the compensation which is to be received by the claimant. The multiplier, I may now point out that deviating from the schedule, Honorable Supreme Court laid down the multiplier system in Sarla Verma versus DTC so and so and concluded as under. So Lordship, I'll skip this paragraph because in that view of the matter, for the age range between age range 26 to 30, multiplier is 17, annual income rupees so and so is equal to 90, deduction half 45,000. Loss of annual dependency, rupees 45,000, multiply 17, loss of total dependency, 7,67,000, 65,000. Future prospect. In the case of National Insurance Company Limited versus PROCEEDINGS, the Honorable Supreme Court had held that while deducting the income for self-employed or on fixed salary, 40% of established income should be added towards future prospect if the deceased was below 40 years of age. Considering the status of deceased as employed in a private firm and aged 26 to 30 years, 40% of future prospect has to be calculated as this 3 lakhs. Conventional head. The conventional head loss of estate funeral expenses is computed 16,500 since 3 years has passed. Since the decision of PROCEEDINGS, similarly loss of consortium will be now granted at 44,000. In the case of an 44,000 is therefore awarded towards side loss of filial consortium. A sum of rupees 16,500 has been awarded under loss of estate and another 16,500 for funeral expenses. That apart, rupees 10,000 is awarded for bringing the dead body from Silchar to Morigao. This lordship is not in the statutory, this 10,000. Thus, total compensation of rupees 11,58,000 only. No compensation is given in any other heads. Whether insurance company is liable to pay the compensation or not. As per the claim petition and accident information report, the vehicle bearing number so and so was insured with Oriental Insurance Company Limited by policy number so and so, which was valid up to 1/11/2016. The accident occurred on 7/4/2016 and was thus within the validity period of policy. Driving license. The insurance company examined 2 witnesses to try and prove that OP number 2 was not competent to drive the offending truck. It has been averred by Mohim Bhuya DW1 and Nitumani Chaudhary DW2 that the driving license of Rohimuddin Bor Bhuya was only to drive LMV and that he was not competent to drive the offending truck. It has been testified by these DWs that the laden weight after goods are loaded of the truck was 10,000 kg. In cross-examination, DW1 admitted that he does not know whether the vehicle was loaded or unloaded at the time of accident. Moreover, as per Exhibit B exhibited by DW1, the unloaded weight was only 6,200 kg. It is settled law that the vehicle below 7,500 kg can be driven by a person holding an LMV license. As OP number 2 was driving a vehicle whose unladen weight was only 6,400 kg, Lordship, this will be important for my argument later on. DW1 admitted that he has no knowledge as to whether the vehicle was loaded or not. In that view of the matter, I hold that OP number 2 was competent to drive the offending vehicle. In the result, the owner has not committed any breach of policy. What follows is that the insurance company is liable to pay the compensation. The claimant is entitled to compensation. So, Lordship, after that, the compensation amount is there. Our basic grievance is with paragraph 29 and 30, Lordship. And protection was also given. And Lordship, about pandemic interest, the court has said at paragraph 33 that interest will not be given as per miscellaneous application of Apex Court, Lordship.
Yes.
So, Lordship.
What is the submission?
So, Lordship, first of all, Lordship, let's read the final report. Lordship will find that at page 90 of LCR, because the court has come to a conclusion that the vehicle was unladen, first of all. Naturally, Lordship, the DWs were not eyewitness. But the court has accepted the final report. And as per the final report, the vehicle was laden. And as per the evidence also, I'll read the evidence of the witnesses also. First of all, let me take Lordship to the final report, Lordship. It is at page 90. More particularly, para 3 and 6.
Yes.
The background of the case in brief is that on 7/4/2016 at around 11:30 a.m., one Tata Hiva, so Lordship, this vehicle itself, the description of the vehicle proves, bearing registration number so-and-so, driven by Rahimuddin Barbhuya, son of Rashid Ali Barbhuya, village Swarnapur, POPS Kathichera, district Hailakandi, Assam, while working at the Thingo workshop, hit one supervisor, namely Polas Bora, aged 18 years, son of Deepak Bora of Nagaon, POPS Nagaon, Assam, on his head by the aforementioned vehicle, resulting serious head injury. Immediately he was evacuated to hospital for medical treatment. However, he was declared brought dead by the medical officer, SMC Silchar Medical College. Hence, a case under FIR number so and so has been registered for investigation into the matter. Hence, the case. During the course of investigation, examined the complainant whose statement corroborated with the OE of the case. Conducted a thorough spot inspection. On inspection, the PO was found located on the worksite of the BIPL camp, Tunnel 2, Thingau. Photograph of the scene of the crime were taken from different angles. A rough sketch map of the PO was drawn with proper index, and the vehicle was seized from the spot by preparing formal seizure memo. It was observed that the road on which PO located have a steep slope towards the tunnel, that any unfortunate incident might have occurred if there is any mechanical defect on the vehicle. It is reported that the unfortunate incident, this part, Lordship, I am relying on, it is reported that the unfortunate incident had occurred while Tata Tripper. So, Lordship, vehicle description, it is a Tata
Who
Tripper.
reported?
Lordship,
What?
Lordship?
It mentions that it is reported.
Huh. No, this was accepted by the tribunal. I read the judgment, this final report, because this is the report of the.
No, you want to rely on this.
Yes, this part, this whole sentence. It is reported that the unfortunate incident had occurred by Tata Tripper bearing registration.
Reported to the investigating. Investigating officer is.
When they inquired.
No, my query is, when investigating officer has filed a final report to the court reporting about his investigation, why he has closed the investigation and submitted an FIR, he ought to have, whether he ought to have specifically mentioned that witness so and so have mentioned how he came to know that it was unladen vehicle.
It was loaded.
Loaded vehicle.
No, I'll read the evidence also, Lordship.
Okay.
PW, because PW, we have not exhibited this document, Lordship. This document is exhibited by the claimant, and it is marked as exhibit Roman 12 in bracket 1.
No, but for emphasizing your point that the vehicle was loaded vehicle, you want to rely on this observation.
Yes, this document, in fact.
This document and this.
This and later on also.
Later on something is there.
And paragraph, in further course of investigation, the accused driver of the vehicle, that para 6 also. Lodged.
Please continue.
It is reported that the unfortunate incident had occurred while Tata Tripper bearing registration number so loaded with construction materials came to the workplace, hit on the head of Polas Bora, who is the supervisor of the worksite of BIPL company, while working in there due to mechanical defect of the said vehicle. It is also learned that the injured supervisor, Mr. Polas Bora, was evacuated to Silchar Medical College Hospital for treatment. However, he was succumbed to his injuries on his way to hospital. In the course of investigation, the dead body of the supervisor, namely Polas Bora, aged about 18 years, son of Deepak Bora of Nagaon, POPS Nagaon, Assam, who had succumbed to his injuries on the way to Silchar for medical treatment, had been conducted post-mortem examination with the help of Ghungru Outpost Police at Silchar Medical College, Silchar. White Ghungru OPGD number 138 dated 7/4/2016. After conducted inquest, collected PM examination report and inquest report from the Ghungru Police Outpost. As per the PM examination report furnished by the medical officer, Department of Forensic Medicine, Silchar Medical College, Silcher indicated death was due to coma as a result of injuries sustained in head as described. All the injuries were antemortem and caused by blunt force impact. There is no indication of the foul play regarding the death of supervisor. It was purely accidental in nature. In further course of investigation, the seized ill-fated vehicle bearing registration number so and so was subjected to mechanical inspection to ascertain the exact cause of accident. As per the mechanical inspector of Imphal West Motor Vehicle Department, Government of Manipur, who conducted the mechanical inspection over the vehicle, had indicated due to slippery brake at the time of accident as the possible cause of accident. In further course of investigation, the accused driver of vehicle bearing number so and so, namely Rahimuddin Borbuya, 40, son of Rashid Ali Borbuya of Swapanpur PS, Kathichera district, Hailakandi, Assam, was arrested and tactfully interrogated in connection with this case. He denied to have driven the vehicle rashly or negligently. He stated that he was coming from the worksite carrying construction materials. So, Lordship, the question Lordship asked Lordship, how the investigating officer found that that material was there. It was laden. It is from this Lordship. Carrying construction material. While approaching on the work site in the slope of the said road tunnel, while Pora also standing and signaling me to turn the vehicle for unloading the vehicle, this Lordship, unloading the material. This is also is coming material on the work site. In a suddenly moment, the brake of my vehicle was not functioned, which resulted my vehicle run down towards the tunnel and hit the supervisor, which resulted in the injury on his body. The supervisor was also tried to avoid by coming towards the side of the road. Unfortunately, he was hit on his hand. I somehow managed to. So, Lordship, rest of the part is yeah. I just wanted to show how since the court has accepted this final report, Lordship, and mentioned in the judgment, it is to be taken fully, not pick and choose, Lordship. Any evidence or any documentary evidence, Lordship, cannot be a pick and choose method by the tribunal, by any court or any tribunal, Lordship. So, Lordship, this goes to prove that it was a laden vehicle. And Lordship, if Lordship needs further clarification, I can read the evidence also. But if this suffices, Lordship, then I'll go to my next point.
Actually, what is sufficient? Whether it suffices or not, for that you have to wait till delivery of judgment.
Okay.
Now I cannot tell.
Oh, okay.
You have to yourself
Yes,
think.
then I'll yeah, Lordship, I'll go to the other.
If you think that something more is required to convince this court.
No, I feel that I have already convinced, but then I'll take the extra precaution.
Yes.
That I think I have already, because that document is already there, it is on record, and it is also mentioned by the court. That is my first ground number A, Lordship. That the learned member at paragraph 15 of the judgment accepts the final report exhibited by wherein it is clearly written that the vehicle was a Tata Tripper. Tata Tripper is a 10-ton truck, Lordship. It is not a LMV. And we proved that the driver had a LMV only. And as per Apex Code, I'll give the judgments also, Lordship. As per the Apex Code, what is to be, while deciding a case, the owner has to prove that the vehicle was driven by a person having a valid driving license and appropriate driving license to drive that particular vehicle. And here in this case, the driver had a LMV. Our witnesses have proved that. Lordship will, if Lordship will take up the evidence of PW1, Lordship, that page I have not written actually.
Yes. Rupa Bora.
Rupa Bora.
Yes, page 50.
Rupa Bora, in fact, didn't exhibit this document, Lordship, what I find. But she filed one application, Lordship. That is dated 11/8/2021, in which she mentions 11/8/2021, in which she mentions at para 3 that the investigating officer of the police case has already submitted the final report in connection with NBA case 9, wherein the investigation clearly reveals that the occurrence was accidental in nature. Hence the provision. This, Lordship, this I am mentioning because, Lordship, I had taken one ground that they had filed one application to convert the case from 166 to 163A. That is my ground number D. But, Lordship, I find that later on they had withdrawn this petition, Lordship. By order dated 13/9/2022, Lordship. That, Lordship, will find at page 15. The order was passed that they were not pressing that petition for conversion. So my ground D, Lordship, will not be applicable here.
I'll take a short break.
19, Lordship. I've already taken the consent of the other side, Lordship. Item number 19. Let it come on Tuesday, Lordship. Tuesday, Lordship. I'm the respondent.
You're seeking adjournment.
Adjournment, Lordship. It's a matrimonial appeal, Lordship.
Heard Mr. R. Sharma.
A. Sharma, Lordship.
A. Sharma, learned counsel for the respondent, who prays for an adjournment. He submits that he has informed the learned counsel for the appellant regarding his prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed. 4th of August.
Earlier, Lordship. In month of July, Lordship.
4th August.
July, in the month of July, last part.
Your two prayer cannot be allowed. Either adjournment will be allowed. 4th August.
4th August.
Lordship, PW2, Lordship, the father of the deceased, who is the alleged eyewitness, Lordship. That also.
Deepak Bora.
Yes, Lordship. Deepak Bora alias Dina Bora.
Yes.
Lordship, at page 2. Apni ki baat ko bone ki.
Father of the claim.
No, kindly.
Second page.
Yes.
Second page, Lordship. That on third paragraph, Lordship. The second page, actually second paragraph. That on 7/4/2016 at about 11:30 a.m. at Tingam project, while my said son was busy with computer for data entry of the unloading material carried by the offending vehicle bearing so and so. So, Lordship, this is the eyewitness. He is also talking about the vehicle being laden. Because the vehicle was being parked to unload the material, Lordship.
He's saying that his son was entering the data of unloading of vehicle.
Yes.
Unloading materials.
Yes. All of a sudden, the back dala of the said offending vehicle fell down due to negligence. Back dala, the tailboard, Lordship.
Okay. Okay.
So, Lordship, from this it is and the insurance company proved that the vehicle did not, the driver did not have a valid driving license.
What is the submission regarding the observation made by the tribunal that even if a person carries an LMV license, he can drive a vehicle up to a certain weight? That weight he has mentioned in the judgment.
No, that weight is, Lordship, LMV weight. 7,500 is the LMV weight.
Yes. And he says that unladen weight of this vehicle was 6,000 something.
That is what we are challenging. That is not a correct observation. Unladen weight whatever the vehicle was laden at that point of time.
How much was the load?
More, because it is a 10-ton truck, Lordship.
No, no.
And as per
I'm
policy,
not on that.
Hmm.
If you are specific, if you are relying on the evidence that it was laden to counter the observation made by the tribunal, you have to show to the court that the unladen weight was 6,000 so much and the laden weight was so much. Therefore, it goes beyond 7,000.
no, the description of the vehicle itself, Lordship, is Tata Tripper. 10-ton, and Lordship will look at the policy, Lordship, insurance policy. There it is mentioned 25,000. The GV of the vehicle, gross vehicle is the Lordship, that is GVW is 25,200. Policy, Lordship, at page 97. That was also proved by the insurance company.
I'm just putting query that your emphasis is on that, on the fact that the vehicle was loaded vehicle, laden vehicle. And therefore, the observation made by the tribunal is wrong observation.
Because, Lordship, LMB, unladen weight itself is as per MB Act, 7,500.
Okay. No, whether the observation of the tribunal is right when he says that a person carrying LMB can drive any vehicle to the.
That, Lordship, Apex Court gave a full bench judgment, Lordship, that if it is a LMB license, an LMB vehicle of any description, that judgment I'll present before Lordship. LMB vehicle of any description, let it be commercial or
Regarding defect in license, there is a detailed judgment of
that
the
is what
Apex.
I'm talking
Karan
about.
Singh.
No, not Swan Singh, Lordship, in 23.
Which one?
That was authored by Justice Rishikesh Roy. I'll give that judgment, or we can adjourn the I'll give Lordship, if a person holds a what that judgment said, that if a person holds a
Regarding any kind of defect in license, driving license, there is a detailed judgment.
I know this judgment, Lordship, if there is.
You complete your submission. If I have any query, I will put.
Because, Lordship, in that judgment, what the Apex Court held, 5-judge judgment, that was a constituent bench judgment, in which what it was held, Lordship, if LMV license, then that person can drive any kind of LMV vehicle. Because earlier, the insurance company used to contend that if it is a LMV private license, then they cannot drive a commercial vehicle. But Apex Court made it clear that if the license is LMV, then the person can drive any kind of LMV vehicle, but he cannot drive a HMV, Lordship.
Okay.
Today I have not brought that judgment. I'll give that judgment, Lordship, to clarify.
Okay, you rely on the testimony of PW2 as well as the final report to show that the vehicle was a loaded vehicle.
Loaded vehicle.
And therefore,
he was. It was in the process. He was.
Accident occurred in the process of unloading of the vehicle.
Unloading the vehicle.
Okay.
As per, and they have. It is their document. I have not even touched my documents, Lordship, what we have proved. I'm talking about the document. It is exhibited as Roman 12:1 by them, final report.
Okay.
Lordship, this MB Act, I'll just read the definition of LMB, Lordship. It is at 21. Definitions, Lordship. Section 221, Lordship.
Yes.
Light motor vehicle means a transport vehicle or omnibus, the gross vehicle weight of either of which or a motor car or a tractor or road roller, the unladen.
Section?
Section 221, the definition, Lordship. In section 2, the definitions of different terminologies are given. At 21 is the LMB, Lordship.
Yes.
Light motor vehicle means a transport vehicle or omnibus, a gross vehicle weight of either of which or a motor car or tractor or road roller, the unladen weight of any of which does not exceed 7,500 kilograms. Lordship. So unladen, LMB unladen itself is 7,500. And HMB before that, Lordship, will find HMB at definition of HMB at 16 and 17, Lordship. There it is 12,000 kilograms or
But
more.
the unladen weight of the present vehicle was 6,200 only.
But it was not unladen, Lordship, it was laden.
No, but by that definition, it will be regarded as an LMV.
No,
Why? Why not?
because of the policy, Lordship, because of the fact that it was a Tata Tripper, because of the fact that the description, the Tata, the mention of the vehicle is
No, section 221 says that LMV means any vehicle. Whose unladen weight does not exceed 7,500 kilogram. The weight of the present vehicle was unladen weight was. It is observed that DW1 admitted that unladen weight as per what is Exhibit B?
Exhibit B is the RC, Lordship.
As per RC, the unladen weight is 6,200.
And laden weight is 10,000 kg.
Maybe, but to decide whether a vehicle is a LMV or HMV, what are the criteria? Criteria is the unladen weight of that vehicle.
But
I am putting query to you.
Yes.
How to ascertain whether a vehicle is a LMV or HMV? It should fit into the definition given by the MV Act 221. Section 2, clause 21 defines LMV.
Yes.
If any vehicles fit into that definition, it will be regarded as an LMV. And to fit into that definition, the unladen weight of that vehicle is to be taken into consideration. The unladen weight of the present offending vehicle is also less than 7,500 kilogram. Then it will be regarded as, whether it will be regarded as an LMV.
I'll have to look into that, Lordship. Can I
Please
take
see.
an adjournment on that point? And also I'll bring the that same kind of vehicle, the judgment on LMV and
Okay, you complete because we have substantially heard.
No,
We will
can be
keep,
part
we
of
will
Lordship.
keep it part heard after hearing the matter.
Okay.
This query remains.
Yes.
Section 221 of MVA. Yes, what is your next point?
Next point, Lordship, that my ground number B is that learned as well as fact not considering that as per the insurance policy, GVW gross vehicle weight was 25,200 kg. And by no stretch of imagination, the learned member could have decided that the vehicle involved in the accident was a light motor vehicle.
25,200 kg.
Yes, as per the policy.
Then how in RC it is made?
I don't know what is the manipulation in that. But as per the policy they have taken at it is exhibited, Lordship. The policy is at page 97. Exhibit D.
Where is the RC?
RC at page 95. Not RC, it is just a report, Lordship. DTO did not come, Lordship. It was by the investigator only. Both the DWs are investigators. It was not proved by DTO.
So 90,
95,
of the
trial court
Trial
report,
court.
LCR, Lordship. 95 is the RC and 96 is the DL. Lordship judgment is there. I know that Lordship said that when the DTO is not called, then that evidence cannot be relied on. Lordship has recently passed one judgment on that point.
It says unladen weight 6,200 kg.
And laden weight 10,000 kg. But the policy says something else, Lordship.
Where is the policy?
Policy at page 97. Just next page is the DL report and then 97 is the policy, Lordship.
Where is the weight?
Weight, Lordship, in between, Lordship. GVW, Lordship.
What is meant by GVW?
Gross vehicle weight.
$25,200.
Yes.
There is huge difference.
It's a huge vehicle, Lordship. Triple, Lordship.
Then how it can be 6,200?
That is what manipulation is there. I do not know, Lordship. I cannot submit on that. But then, as per the policy, the vehicle weight was that much, and that is what the policy the owner had taken. And that is why, Lordship, the driver could not control. Either it has to be remanded back for fresh by calling the DTO personal, Lordship, with a specified time like 3 months or something.
Okay, you complete your submission.
Yes.
Or we keep it part heard. Let her answer the queries. We'll take it up on next Tuesday. Next Tuesday. Because unless you answer these queries,
No, Lordship, even I have found that there is a discrepancy in that. That's why I'm submitting, Lordship. And Lordship passed a judgment that if the insurance company wants to prove about the driving license, they should call the DTO. I'll give that judgment also. But so apex court judgment is there, Lordship, wherein it is mentioned that it is the owner who has to prove that the driver had a valid driving license. That judgment, Pappu judgment.
we are adjourning it till next Tuesday. Heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. S. Ali, learned counsel for the claimant respondents.
Tuesday,
The learned counsel for the appellant has made substantial submissions, though has argued substantially in this matter. However, one more query was there. No?
Section 221 query was there.
However, during the course of argument, it came to the light that as per Exhibit B, that is the verification report of the District Transport Officer, Thoubal, Manipur, the unladen weight of the offending vehicle is shown to be 6,200 kgs, whereas as per the insurance policy, the gross vehicle weight shown in the insurance policy is 25,200 kg. It also stop. On this, a query was posed by this court. If the unladen weight of the vehicle is taken to be 6,200 kg as per the verification report, whether the offending vehicle would be regarded as a light motor vehicle within the meaning of the definition of LMV as given in section 2 within bracket 21 of the MV Act. On this, learned counsel for the appellant sought some time to answer to the queries and also bring certain authorities on this matter.
And another query, Lordship?
One is 21,
Uh,
whether
221, I got it, Lordship.
221.
Another query, Lordship said another query, only this.
This query another is the discrepancy between RC and
Policy.
If you want to make any submission.
Yes.
Query is only this much.
On that, Lordship, I would say
Because
that it has to be remanded back for.
Because your submission is not yet complete. You can make any other additions.
Yes.
And he has to yet to start.
Yes.
Stop. Accordingly, let this case be listed again Tuesday, 21/7 as part and matter. This case will be taken up as first hearing item in the hearing list on that day. List accordingly.
Item 17.
Lordship, I am for respondent number 1. Officially, I cannot take up this matter because I have been empaneled with the appellant recently. So I have intimated it to my client, Lordship. So he will engage somebody else.
Heard Mr.
Ekakoti.
S. R. Sharma, learned counsel for the appellant. Also heard Mr. A. Kakuti, learned counsel for respondent number 1, who submits that he has been recently empaneled in the appellant's insurance company as a panel lawyer, and therefore he may not be able to take up the matter of take up the brief for respondent number 1. He submits that he has informed the same to the respondent number 1 with a request to engage a different counsel, and therefore he prays for an adjournment today. The prayer is allowed. Let this matter be listed after 4 weeks on a date to be
Another
fixed.
thing, the statutory fees that has been ordered by this honorable court has not been paid till date. In this matter, I have checked with the registry also.
You have not.
While granting the stay, Lordship, 50% award has been of the awarded amount has been deposited.
Now you are in their panel.
I cannot submit.
You tell them to deposit statutory. You advise them to deposit this statutory. I am not making any observation.
I'll verify that. Obliged, Lordship.
Argument 12.
May please, your lordship. Yeah, my lord, I have to prefer this appeal. My MSCB case was dismissed on the ground.
Dismissed.
Yes, my lord, on the ground that in the FIR, the vehicle number was not there. But whereas in the scissor list, the vehicle number was there. In the charge sheet has been filed against the driver. that was not taken into consideration. Straightway, since it is not in the FIR, so it was claim was dismissed, my lord. That is why I am before your lordship. My lord, your lordship also knows that the MBI report, Caesar list, the part of the record, my lord. In the Caesar list, the vehicle is there, number is there. In the MBI report, there is a number also. So it was already been settled by the apex court also that if the Caesar list and the MBI report and the charge sheet is there, then there is no question of dismissing the appeal on the ground of non-mentioning of the FIR vehicle number in the FIR. That is only ground before your lordship. Even the PW2, the witness who was with the victim, he has stated in his evidence the vehicle number. That was not rebutted by the insurance company also. PW2, my lord. He has stated that I was with him when this accident was occurred.
In accident information report,
Yes, FIR.
Vehicle number was given. Accident information report.
Yes, basic information.
Form 54. In Form 54, whether
Yes,
vehicle number was given or not.
Yes.
the vehicle number was given there. 15.
Exhibit 1.
Exhibit 1, your lordship.
Okay.
In FIR not given also.
In the FIR, it is not
No,
given.
also, no GDL. I must clear it.
No. In the 54, it was given.
For everything is there.
Okay, what is the submission?
My lord.
Read that portion in the impugned judgment whereby the tribunal dismisses all
Yes.
that reasoning.
Yeah. That your lordship will come.
Which
Paragraph 15, my lord. 14 onwards, my lord.
Yes, 14 and 15.
I have perused the FIR drawn by the OC Digboy, PS, wherein it appears that the accident occurred on 14/8/16 at 9 p.m. on the Sunday. The information received on 18/8/16 at 10 at 3 p.m. against the column number 7 in the details of the known suspected unknown accused. It was mentioned as unknown vehicle as it was appear from the chronological history of the case that the accident occurred on 14/8/16. GD was recorded from the formal FIR was filed on 18/8/16. Now in the formal FIR, it was stated the vehicle was unknown, which however have supported the contention of the GD entry to. But in the police has submitted the charge sheet. It is alleged that the OP insurance company that the charge sheet is insufficient because there is no mention about the vehicle number. But the name of the driver Sanjeev Gogoi was mentioned against the name and the address of the accused person. Admittedly, OP number 1 and 2, the driver and one Mridul Gogoi did not contest the case and the case proceeded ex parte against them. Now, under the meticulous perusal of the charge sheet, it appears that one Padma Bora, wife of the late has filed an FIR stating that on 14/8/16 at about 9 p.m. an unknown vehicle dashed for her husband and from his backside in the front of the DFO, Digboy, which led to them to treat the hospital. Accordingly, the base of the FIR has registered a case being the 136 so and so, and the matter was investigated. Now, after being investigated, the case during the time of investigation said Dharma Gogoi died in the hospital, and for which under 304 was added to the existing offense, and accordingly, case was found to be established against the driver Sanjeev Gogoi, son of so and so, and the trial was under 279 and 304, and subsequently he was forwarded to stand trial. Interestingly note, there is to show that in the charge sheet as to how and under what manner the investigation was conducted by the police, and to show the involvement of driver in respect of the vehicle. The cause was that caused the occurrence on the day. The name of the owner of the vehicle was not mentioned in the charge sheet, and there is nothing to show that the driver Sanjeev was a driver of the said Maruti Swift being so and so. So in the existing materials on record, is found insufficient to hold the view that the vehicle number 1 Maruti was involved in this case and it was driven by Sanjeev Gogoi at the time of relevant time. Interestingly, the claimant has not mentioned the name, the owner of the vehicle though one middle Google was found to have been read as the opposite number, but nothing is there to show on what capacity he was made the OP in this case. Considering all this spectrum, I am the view taken the insurance company that there is a strong suspicion as well as a discrepancy arose in formatting this and get the substance. Having considered this aspect, I am of the view that further discussion of the case is found to be unwarranted and hence the claims stand dismissed on contest for want of proper parties to be made in the party in the case.
Yes, now what is your case?
My lord,
What is your case?
my case is, my lord, in the MBI report, there is a vehicle number is there.
Where is that MBI report?
MBI report.
MBI report was exhibited
Yes.
as exhibit,
It's a part of the chart sheet.
as exhibit.
I'm just coming. The Caesar list is exhibit 5, my lord. 5 and 6, my lord. Caesar list
5 and 6.
is a Caesar list. MBI report is exhibit 5, 7.
5-7.
Where is the sum?
The evidence to make a PW1 about it. PW1. Another evidence to say.
Yes, where is the vehicle number?
Charge to be. Charge to police. The same applies to the
Or we'll take it after some time.
After some
You,
time.
because you appears to be not fully prepared.
My lord.
You are not fully prepared.
Fully prepared. Some misplacement documents. I am fully prepared, my lord. Lordships.
Your case is that though court tribunal held that the vehicle involved in this case could not be identified.
According
The
to this
tribunal,
Tribunal.
because there was no mention of vehicle
number in
number
that.
in the FIR as well as in the charge sheet.
Charge.
Your case is that the vehicle was identified in the vehicle by mentioning the vehicle number in Caesar list as well as in
MBI report.
MBI report.
Even the PW2 has also
So,
stated. PW2 has also stated that the vehicle number, the insurance did not cross him on that point, pilot. PW2, your lordship will see, he has stated that the number of the vehicle number. My lord, if your lordship, the question that raised, it is already decided by the Bimla's case, my lord, in the Supreme Court. Charge sheet, Caesar list, MBI report is sufficient.
no, where is the vehicle number in the
PW1, PW2, my lord, evidence of, in the affidavit PW2.
And documents, who is PW2?
He is the witness, my lord. He was along with this man when the car hit him.
Eyewitness.
Bhanakanta Bora.
And what are the documents which indicate the vehicle? What are the documents where vehicle number has been indicated?
That is the MVI report and Caesar list. MVI report and the Caesar list
MVI reports, it is exhibited as?
as exhibit 5-7, my lord. 5-7, exhibited 5-7.
5-7 is the Caesar list.
No, my lord, I have the MVI report. This is MVI report, my lord. 5-7.
6 is the Caesar.
5-6 is the Caesar list.
Then either you are wrong, you are submitting wrong, or the documents before me is wrong.
So you can verify it.
Yes, yes. I'll see.
This does not tally
It's,
because here 5-7 is the Caesar list.
then it is here. We have put it here.
Here 5-7 is the, you
MBI.
verify from the,
MBI.
cross verify from the.
Yes, yes. I'll verify.
That does not tally with the record.
Yes, I'll verify and at 2 p.m. my lord. I'll say.
Okay, we'll take it up at 2 p.m.
Yes, my lord.
ইয়াতে থাকো জোরে মাতি ইমান মাতি 18
My lord, here is the case, my lord. We have changed the order that your lordship will see the impine order. It starts from, my lord, page 66, my lord. Before coming to that, my lord, I like to apprise that, my lord, the appellant filed a title suit before the concerned civil judge, my lord, Dibrugarh, by page 31, annexure 1, seeking compensation of 5 crore 25 lakhs as a civil defamation suit, my lord.
Okay.
As a case of that, my lord, a case has been registered at the instance of the respondent number 2, my lord, or a sole respondent who was the then time, my lord, police IPS officer and superintendent. He lost a case there in the Dibrugarh, Karimganj, my lord, and accordingly, my lord, the police personnel of concerned police station went to the Dibrugarh, caused a search, and all the seizure was made. After conclusion, my lord, the trial by the IO, my lord, because it has gone in the meantime, my lord, High Court also we came for quashing of the FIR. Then, my lord, it has
No,
gone
FIR was lodged against you
against me. I
by
was
the SP.
By the SP, I was the deputy superintendent of access. Thereafter, my lord,
You were deputy superintendent of excise
my lord,
at that point of time.
that point of.
Okay.
Thereafter, my lord, I filed a case before quashing of the case, my lord. That was not fruitful result, my lord. Accordingly, I have gone to the apex court. Apex court referred the matter back to the authority. Authority, after conclusion, my lord, filed the final report. Final report, my lord.
Authority means?
My lord,
Which authority?
police authority, I mean to say. Police, my lord, DIG, my lord. Supreme Court, my lord, directed to the officer above the SP rank to investigate both the cases. There was another case also, my lord, which I have filed.
Okay.
Then, my lord, FS Court directed to the authority, that is the state government, my lord, above the SP rank to conclude the investigation. Accordingly, my lord, in the list of document, lordship will see 12, 13, and 14. was the final report and it has been accepted. Well in time, my lord, we did not do anything. Accordingly, we filed one criminal defamation there in the trial court as well as the civil defamation in the
And
cause
civil
of
def-
action.
civil defamation was dismissed.
Dismissed, my lord, against which I am before your lordship.
Okay.
That, my lord, starts, your lordship will see the judgment starts from page 66, A to the end. And during trial, my lord, 5 number of issues were framed. That I am taking your lordship to page 83.
Yes. Yes.
1, 2, my lord, is the general, my lord, maintainable. 3 is the cause of, 2 is the cause of action. 3 is the important, my lord. Whether the defendant had a maliciously prosecuted the plaintiff under Karimganj PS number so and so causing damages to
But
her.
prosecution never started. You said that it was ended in final report.
Yes, my lord.
So
After final report, my lord, the concerned court has accepted. Then, my lord,
there was no prosecution.
there was no prosecution, only investigation.
Then how it can be malicious prosecution?
That I'm coming to that.
Okay.
That is my case. Then, my lord, page 83, my lord, 5 numbers of issues were framed, my lord, and I have exhibited all the relevant documents. Issue was, 1 was affirmative cause of action was there, my lord. 2 is also there, my lord. 3, lordship will see page 86, my lord. Inner column, page number, serial number 10.
Page 86.
86, issue number 3, serial number 10. Inner page, paragraph number 10. That I need to read, my lord.
Yes.
May I read, my lord?
Yes.
Issue number 3, whether the defendant had maliciously prosecuted the plaintiff under Karimganj PS case number 483 of 2011 causing any damages to her reputation. At the outset, the discussion having the capability on an impact of the determination of the plenary scarks of the dispute has been arisen between the parties. It is pertinent to bring into record or reflect that the clear unequivocal terms and determination of the third issue itself requires further determination of 2 vital parameters which are as follows. Adjudication of malicious prosecution alleged to have been instituted from the side of the defendant against the plaintiff, and B. Adjudication of the defamatory allegations in the list have been made against the plaintiff in the first information report that was lodged by the defendant before the officer in charge Karimganj police station. Moreover, from the hardship of the keeping aside the discussion in the instant issue, it is pertinent to reflect that reflect the allegations which are caused both the parties instant suit by imputing accusations against one another has got is direct breaking of the reputation and status of both individuals being so. Although the documents available on the record reveals that the certain serious and sensible information relating to the dispute has been taken place between the plaintiff and the defendant, yet same are to be discussed and reproduced much in details during the discussion of the present issue of the judgment. Because of this court is of the considered opinion that both the plaintiff and defendant are government servants occupying the considerable rank, and respective departments are revealing certain data and appears to have record disgrace identity and would also be in lower image as well as layers of the couple's reputation and concerned departments deemed as an opinion of the society at large. Hence, those documents, although analyzed and discussed, appreciating the issue are not produced in the minute details of the drafting of the judgment, bearing the unavoidable relevant portion of those circumstances which may be a part of the analysis is panned down while drafting the instant judgment. That being stated, the above come to the question of the appreciation of the necessary determination of the alleged institution of malicious prosecution against the defendant plaintiff in view of the point of lodging the Karimganj PS case number so and so. At the outset, the discussion, it is pertinent to reflect that the undeniable parameters of the discussion, which are indeed of the essence for the determination of aberments of malicious prosecution, reflected down the same appears as follows. Then page 89, brief overview of malicious prosecution is ingredients and role of the investigation officer vis-a-vis norms of the investigation in the light, the contents of the FIR as it appears, the genesis of the law laid down by the apex court in the judgment, brief overview of the malicious judgment. In this context, continuation of the above, thereby moving towards the term malicious prosecution, enable a person to glance at the meaning that the said term appears from the discussion made from the Hardsbury Law, 4th edition, and this is of his own, my lord, projected by the learned trial court. Hansbury Law of the England, as well as the Black Law Dictionary, wherein the same is categorically reflected as follows. Definition of malicious prosecution in view of the point Hansbury Law, England edition. It is pertinent to reflect that though analytical discussion, malicious prosecution is found necessary for the point of determination of present issue, yet for a better meaning of the interpretation of the same is equally important to discuss the term of the prosecution in view of the Hansbury Law. Then, my lord, the Hansbury Law of the England version was reproduced. Thereafter, my lord, page 90, after quoting that, my lord, the quote below found, my lord, 10.6, page 90. In view of the above, after addressing the prosecution, it is notably to reflect that the term malicious prosecution from the same source has been reflected above. Accordingly, the definition of the term malicious prosecution is reproduced. Now, my lord, he himself defined another definition. What is the malicious prosecution? Malicious prosecution is the abuse process of court by wrongfully setting law into motion in a criminal charge to be the actionable as a tort of the process must have been without reasonable and probable cause must have been instituted or carried on maliciously and must have terminated the plaintiff's favor. The plaintiff must also prove the damage. In the like manner, the discussion of the term the malicious prosecution is found to be from the book's Black Law Dictionary in the said term. Analyze the view of the determination of the instant. Definition of the malicious prosecution from view of the Black Law Dictionary. In the like manner, it is pertinent to mention the malicious prosecution found necessary from the view of the determination of the present issue for the better meaning or interpretation of the same. It is important to harp the term the prosecution from view of the Black Law Dictionary. Accordingly, same is reproduced. Prosecution 16C. The commencement, these are the definition from the Black Law Dictionary. Then Lordship will see 10.11. In the light of the discussion arises about the term prosecution, it is indeed necessary to the further discussion the term criminal prosecution, which is reproduced from the above source. Accordingly, the same appears to be as follows. Criminal proceeding, judicial hearing of the session prosecution in which the court adjudicate whether the person committed the crime or, having already fixed the guilt, decides the offender's punishment criminally. In the continuation of the above, it is noteworthy to produce the definition of the term proceeding, and after executing it has become to the said process of the term proceeding. It is what they used to express the business done in the court, expressing proceeding in the court of the day done by the direction of the court is implied. It is more comprehensive that the word action, but it may include its general sense all the steps taken, measures adopted by the prosecution or defense or of an action, including the pleading judgment as applied to the term of the proceeding, include the institution of the action, appearance of the defendant, all the ancillary provisional steps such as arrest, attachment, property, genuineness, this read exact, the proceeding, the pleading, the taking of the testimony of the before trial, all the motions made in the action, the trial court, the judgment, the execution, proceeding, entire part, my lord, that may be skipped. The judgment, how the trial comes, my lord. And upon subconjunct reading of the aforesaid term in the light, page 93, 10, 14, my lord. Upon hearing the conjoint reading of the aforesaid term, it is the light of the aforesaid discussion through the clarity at term, the prosecution, and also the term criminal proceeding, the terms of the malicious prosecution extracted from the black law according to the same appears to be as follows. Malicious prosecution action of the defined the judicial proceeding instituted by one person against the another person for wrongful and improper motives without probable cause to ascertain. It is usually carried out the malicious prosecution when the action damages to the subject to such suit is called for. The malicious prosecution, the strictness of the prosecution might be the malicious, that is the brought to the unlawful motives, although the founded in the good cause. It is well settled, established that unless the probable cause of malicious occur to the damage are recoverable from the blameworthy was the prosecution motives cannot be the cast upon the damage if there was a probable cause for the complaint he made. Hence, the term usually report. To that effect, my lord, I like to reply, my lord. Lordship will see the list of document, list of document 12, 13, and 14, my lord, acceptance of the final report and submission of the final report. There, my lord, trial court has found, my lord, why the final report was accepted by the competent court, my lord, at where, my lord, affair was lost. As such, upon the comfortable as well as the conjoint reading of the reflected above, and the furthermore keeping in the note of the impedance scope of the legality defined meaning of the term, the malicious prosecution always appears to be apparently visible from the court. It is of the order to attach the term malicious prosecution, the essential ingredients of the prosecution carrying out the judicial proceeding before the court of law is under antecedent condition which is necessary to be made out for the reason having been prosecuted. Because of the term proceeding is the word in which express business done in the court in a criminal proceeding. In this case, the which by way of judicial meaning and education appointments allege of the crime of the individual, the being prosecution and the malicious prosecution has got its direct bearing upon the institution of the proceeding before the court in the form of the trial so as to abuse process as well as valuable time of the court coupled with the wrongful setting of law in motion. Criminal charge weakening the grade of the valuable at the individual being so the same is the ambit does not include anything to be done before the investigation agency as it appears the facts narrated in the instant case. Accordingly, from the discussion, it is aforesaid parameters. It has been manifestly clear that the malicious prosecution within the ambit of the reflect institution proceeding before the court of law means the abuse of its authority for the purpose of causing undue harassment to the individual by the person in order to settle the vigilance.
We'll continue at 2. At 2 we'll continue.
Mild, sorry.
First time I have appeared today, my lord. I have taken the consent also from other side, my lord. Maybe I come up after 3 weeks, my lord. I have to collect some trial court record also. 26, my lord.
Heard Mr. N. Uddin, learned counsel, appearing for respondent number
2, my lord.
2, who seeks an adjournment. Why adjournment?
Well, I have newly engaged in this
As
case.
he has been newly engaged in this case. Learned Miss R.D. Majumdar, learned counsel for the appellant, does not raise any objection.
Do raise, Lordship, but then Lordship will allow. Because I have read they do not inform on the day before. They should inform night before, so that
Though
not
objected to the prayer for adjournment, however, considering the submissions made by learned counsel for the respondent number 2, the prayer is allowed. Let this matter be listed after 4 weeks on a date to be fixed by registry.
I am obliged with.
Lordship, in item number 21, similar prayer, I am appearing for respondent number 2 and 3 for the first time. So I need some time.
Miss, what is your name?
G. Swami.
G. Swami, learned counsel for respondent number 2 and 3. You have
again
informed
oppose. No, just now she has said. So again oppose, but Lordship might.
2 and 3, who seeks an adjournment on the ground that she has been newly engaged in this case.
Sure.
So,
I've received the notice. I'm appearing for the first time, not newly engaged.
It is newly engaged only. That is newly engaged only.
For respondent number 2 and 3.
That is.
but this is hearing matter.
That's actually the notice has been received by us on 24/4. The date is 24
But
April.
that cannot be because
That what I didn't understand. How
It cannot be.
we have received this one.
No, you have received maybe from your party. That is a different issue, but notices were sent.
Notice from the.
okay, you go through the record, but you are not prepared for hearing today. Okay. As she has appeared in this case for the first time and is not ready for the hearing, but though Miss R.D. Majumdar opposed the prayer for adjournment, as well as Mr. R. Deka, you are also opposing. Respondent claimant, you are opposing or not? Also oppose the prayer. However, considering the grounds stated by learned counsel for respondent number 2 and 3, the prayer is allowed. Let this matter be listed after 4 weeks. Date will be in October. Let this matter be listed again, 13th of October.
1 month.
That's what I am saying. If you don't want date, we after 4 weeks on a date to be fixed by registry. Yes, Mr. Puyen.
No. My lord, before lunch, my lord, we were at page 95.
Yes.
95 it reads, my lord, 10:17. Accordingly, from the discussion made above paragraphs, it become manifestly clear that the term malicious prosecution within the ambit of reflection institution of the before the trial of the law means abuse of the authority for the purpose of causing undue harassment an individual by a person in order to settle the business against the such individual. Then being the position of the law, it appears that the bear unto state perusal of the Hansberry law, 4th edition, black law, the next parameter need to be determined by this court with reference to the role of the investigation officer. Now then, in the light of the contents of the affairs, to have the genesis of the discussion made by the apex court in view of the notable judgment. However, before proceeding the same, it is needed to necessary that part to reproduce the contents of the relevant portion of the FIR which is lodged by the defendant against the plaintiff in order to start the criminal investigation into motion. The said process of the contents of the complaint which is lodged by the defendant before the Karimganj police station was exhibited by the plaintiff as a part of Exhibit 7, my lord, and reproduced that very FIR, my lord. Here, my lord, inviting to the that is the officer in charge Karimganj PS so and so information report. Inviting to the kind attention above mentioned subject, I would like to inform you that the following. In the year 2009, it was posted as an additional SP Debrigar. One day, I received a telephone call from the lady who introduced herself as a Mrs. Borsavara Bordalai, the then Inspector of Excise Debrigar, and requested for rendering police help for an excise raid, which I had instructed my subordinate to do needful. Later, in the month of February 2009, while I was posted as Superintendent of Police Tinsukia, again this lady called up. From the onwards, he started calling me on different pretexts. Over the period of time, I realized that the Varshabara Bardale had some other intention in her mind and trying to establish a proximity with me to fulfill her unethical and unreasonable demands by taking advantage of my innocence behavior. I gradually started avoiding her calls to get rid of the trap laid by the lady. Mrs. Borsa Bardale started threatening and blackmailing the tactics, starting calling me and sending the SMS through the SMS odd hours at night. The said lady even called up at night on my wife's mobile number, which collected from the somewhere with some malicious intention in her mind. The contended that her by saying that she would spoil my reputation image if I didn't agree to her demand. Obviously, and stubborn behavior of Mrs. Bordala forced me to my wife to change mobile number. Said lady collected the phone number of my near relative, that is my brother, mother, and sister-in-law, and started harassing me and harassing them by calling and sending the threatening SMS. The lady started calling up obviously and so and the landline phone, and even the called up the subordinate officers, my PSO, then conveyed to me. Unless I received the calls and talked to her, she would lodge false allegation against me. On 37/20, Mrs. Bordale sent a handwriting letter to which was delivered to my then confidential assistant at Tinsukia office, where she threatened to destroy my reputation and image unless I do as she said on so and so. The written letter sent by Mrs. Bordale was delivered to me and confidential so and so, wherein the lady demanded something and impossible for me to accept. It is the unethical, immoral so and so. In the next para, in the meantime, the lady collected my mobile number and started calling up and sending threatening SMS from mobile number so and so. So and so, this process of sending threatening SMS odd hours had been continuing till today. In the some message calls and demand from me to submit her wild, illegal, and unethical. So and so responded to her demands and showed her color and started living well as the direct threat from the mobile phone numbers, SMS, so and so. Then, Lordship, after that, my lord, in view of the contention of the parameter of the role of the investigation vis-a-vis norms of the investigation in the light of so and so appears to the genesis of the law laid down Apex Court. The role of investigation officer in the norms of investigation in the light of the contents of the FIR from the contents of laid down by the Honorable Apex Court in view of his notable judgment. The facts of the suit analysis from so and so investigation officer lodged an FIR under the genesis of the law and Honorable Apex Court so and so. There, my lord, it has been referred several judgment that will check it afterwards, my lord. Then, Lordship, kindly come to the page number 100, last paragraph. It is important to notice that herein investigation is concluded conducted by the officer in charge of the police station by the subordinate officer by virtue of the one other provisions of to dispute. Subordinate officer and steps of the investigation, such subordinate officer to its report to the result of the investigation to the officer in charge of upon the completion of the investigation. It appears that in charge of the police station there is no sufficient evidence, reasonable ground he may decide to release the suspected accused. If it is the custody of his executing bond, it however appears to him there is a sufficient evidence or reasonable ground to place the accused for the trial, so and so to take steps thereafter under section Code of Service, either of the completion of the investigation, he has to submit a report 17 under section 173, so and so. There, my lord, law point was discussed, my lord. Here the core issue before your lordship is that, my lord, I have adduced several evidence, my lord, that has not taken into account. And the learned court below, my lord, basing on, my lord, of his own definition, Blackberry and Black law, my lord, he defined that what is the prosecution or what is the malicious prosecution. Now the question comes before your lordship is that, my lord, after filing the closure report, because, my lord, I challenge the quashing of the affair, it has gone to the apex court, which is there in the LCR, my lord. I'll show your lordship, my lord. So now core issue is that, my lord, without discussing any material, I have brought, my lord, evidence that has not taken into
What
account.
evidence?
Evidence, my lord, I have given, my lord, in support of my case, my lord.
No. What the trial? Why the trial court dismissed your suit?
Trial
What-
court dismissed, my lord, because
What was ultimately crux? What was held?
ultimate crux, my lord, he said, my lord,
This is not a prosecution.
this is not a case for the defamation. Their order part, lordship,
No.
will see 118, my lord. If your lordship allow me just to read, my lord.
You are reading for last half an hour.
Yes, my lord, to bring.
My query is ultimately what court held?
Court held.
Why? What was the reason for
Yes, my lord.
dismissing your suit?
Yes, my lord. Court held at 118, my lord. Page 118. On the basis of the elaborate made in the as well as upon the appreciation of materials available, it appears that the plaintiff failed to prove of herself and her family members being defamed. And the trial court said, my lord, my family members and myself was not defamed by way of adducing cogent
No.
evidence.
Whether it was a suit for defamation
My lord, that
or
my lord,
malicious prosecution.
that I have filed, my lord, I have annexed the copy of the plaint of the title suit, my lord, that your lordship will see at page 31. Page 31, it was the title suit, my lord. And prior portion of the trial suit, page 48. Thirty-one is the plaint, my lord, operative part of the prayer is at page 48. I prayed for a decree in favor of plaintiff and against the defendant for general damages.
On account of?
General damages deemed fit proper by the honorable court. A decree for defendant for rupees so and so only for the account of special exemplary damage for this. I asked for the damage, general damages.
On what account?
On account because of the reason is that, my lord, FIR has been filed there.
No. My query is it a suit for defamation? Is it a suit for malicious prosecution? What you allege that you are subjected to malicious prosecution, therefore you should be compensated, or you have been defamed, therefore you should be compensated. What was your case?
My case was I was defamed.
Where is that?
My lord, I was defamed. In the plaint itself, I have written, my lord. Page 38, para 10, my lord. For the instrument of the said private vendetta of the defendant, that to ulterior motive to pressure the plaintiff, and plaintiff along with her husband filed an application 482 criminal petition for quashing of the sentence, said was filed by the before the honorable court. That is the only reason, my lord.
Where? Page?
Page 38, paragraph 10. 9 and 10 will do, my lord, but precise case, my lord, lordship will see at para 10.
Para 10 only narrates certain facts.
My lord, why, my the actual, my lord, crux of the case, my lord, that I filed a title suit. It was, my lord, ulterior motive and harassment and defamed. The moment police goes to the resident with the media and cause a search, my lord, of the
Where is that averment that you have been defamed in your plaint? There has to be an averment in the plaint.
Yes, yes,
What
yes.
wrong was caused
Yes,
for
yes.
which you are seeking compensation?
Yes, my lord. Then, my lord, I may be permitted to read para 9 of that plain, my lord, at page 36. The plaintiff came to know about the false and fabulous complaint of the defendant only on so-and-so, where the police party of the Karimganj PS in the early hours on so-and-so to the residence of the defendant made a certain search without disclosing any seizure numbers of the Nokia mobile and SIM cards and iPad, laptop, and which were also there was no complaint in the affair. Issuance of the seizure list to the plaintiff. The said mobile phones and iPod various relevant messages of the SMS stored and various incoming outgoing messages of the defendant plaintiff saw the reasons to believe the seizure made by the police party in order to destroy the submitted the authorities concerned in view of the fabricated complaint and harassment being caused to the plaintiff officials Karimganj at the behest of the superior officer defendant along with her husband compelled to file an anticipatory bail which was taken in black back thus taken the manner in the investigation was carried out by the authorities in the affair by the compelled the plaintiff to approach the honorable court. Then Lordship 910 you have read and Gauhati High Court dismissed the so and so. The plaintiff constitution of the
Yes.
then my lord para 16, my lord, the acts of the defendant misusing the position of the sending police party, so and so the home of the plaintiff on the basis of the false and fabrication has caused immense, para 16, my lord. It has caused immense damage and reputation of the plaintiff and her family in the society where they live. The allegation means it the are fabricated false information. The plaintiff holds good reputation and dignity of the para 16, my lord. Somehow it has been mentioned. Have been spoiled and by implicating the plaintiff in the false and so fabulous criminal charges against that. The plaintiff, who is the government employee, has been doing all her discharging duties with the blemish and stigma in her career. The criminal charges made against the plaintiff had led to to lose her reputation and dignity in her workplace as a compassionate person in view of the false and fabricated evidence would the impression that the plaintiff is a person of being criminal character. Along with her husband, have formed a criminal counsel to extract defendant. The people established that the plaintiff works and also form the awful opinion as regards the plaintiff's character and on the basis of the false and fabulous. 16, my lord, it has been stated. 17 also, my lord.
So according to you, this is a defamation suit?
My lord, defamation suit.
Yes or no?
Yes, my lord. To that extent also, lordship will have to examine and I'll come with the judgment also on the next.
It is not a suit for malicious prosecution.
Exactly, it is not there. Exactly from the prayer portion and the title suit, my lord, it reflects, my lord, I ask for the damage.
No, damage on account of what?
On account of filing the case and sending police, 16 I have stated, my lord, they have spoiled my reputation. But nothing
So
else.
you have been defamed.
Defamed.
Okay.
By virtue of this thing. Now, my lord, lordship will have to examine one thing, my lord. Lordship kindly take up the, my lord, the paper book. If your lordship allow me, my lord, I'll just flag it up. It would be a more copy for a day. The Supreme Court, why the case has come to the Supreme Court, there is a small order, my lord. That I'll put the flag mark and final report accepted order. It was to flag mark ase na. Tate milai dia, itu bostu to. Flag লৈ লোৱা তাত পৰা মিলাই নিদিবা আমাৰ খিনি separate থোৱা. And there is, my lord, nothing in the record will see, my lord, why the learned court did not discuss anything about my prosecution witness, my lord. I elaborately brought none. There is not single discussion or whisper anything about.
What are the issues
There is the 5 number of issues have been framed by the trial court, my lord, that your lordship will see at page 5 number of issues, my lord. 3 is the vital at page 83. Like my dear, Supreme Court order 2, my dear. Number 1, maintainable.
issue was only regarding malicious prosecution.
My lord, that is, my lord, the maintainable in the suit, whether the cause of action of the suit, whether the defendant maliciously prosecuted.
Yes. So
that is
from issue, it appears that
my lord.
this is a suit for malicious prosecution. Nowhere any utterance about defamation.
My lord, what serial number 4, issue number 4, whether plaintiff is entitled to any relief as claimed for. That will suffice. 4, my lord. And there is also 5. To what relief parties are entitled. Though there is a, my lord, elaborate specific issue ought to have been framed. It has not been.
Okay.
Now lordship has seen, my lord, I have shown the plaintiff. What is my case about? My case about.
That I am not understanding. What is your case?
My case is title suit, my lord. I filed seeking some damage.
No, is it your case that though the trial court framed the issue as regards malicious prosecution, but actually it was a case for defamation?
Defamation,
defamation suit,
my lord.
When it ought to have framed an issue.
Yes, my lord. Ought to have taken some relief, my lord. Serial number 4, page 83. Because whether the plaintiff is entitled to relief as claimed for, there is no specific anything, my lord. Issue number 3, my lord, of his own, he has discarded everything, my lord. Lordship, kindly have a look the flag mark. This is key color. Key color flag this is yellow. Etai this is only one. Lordship can note down, my lord. I remember that document, list of document 12, 13, 14. It is there, my lord. My learned brother could not. 12, 13, 14. That is the final report. And why Supreme Court remanded back to the and directing the police authority to appoint a senior officials above the SP to complete the investigation. Had it been there anything, my lord, issue number 4 and 5, there ought to have been something, man. And more interestingly, lordship will see from the impugned judgment that the trial court of his own motion, my lord, he has elaborated new definition of the malicious prosecution. Whereas my simple suit was for that damage caused to me by virtue of the police authority misusing the case. But that where nowhere was discussed. That apart, my lord, that apart, lordship can note down, my lord, the list of book to the a list of document asset. What I say? It নয় certify copy. Mark করে it হয়েছে এইটু flag মারা in the title suit, lordship will see all the thing is there, my lord. If your lordship permit me, I can show, my lord. Lordship can compare afterwards. It is a certified copy I have obtained from the trial court.
No, what you want to say?
There, my lord, the final report, submitting report, acceptance report, seizure list, the cost to my house, all things are there.
So what you want to say?
I want to say, my lord, the police misuse their power and I was being defamed by virtue of the exercise of the police. He being a superior authority, IPS officer, directed his authority and misused his power. As a result, I suffered my reputation in the society, and it was, had it been anything but in his favor, then, my lord, I have no case, my lord. But ultimately, my lord, court accepted the final report. In the finding of the trial court, my lord, by the accepting, my lord, it seems that, my lord, it is a false case, for which, my lord, no protest petition or nothing has been given, my lord. And there is no discussion about the evidence which I adduced. Good number of evidence I have adduced. There is no discussion what we said, how it is not been relevant. And, my lord, there is no specific issue has been discussed in respect of issue number 4 and 5. But the trial court, my lord, mostly relied upon the issue number 3. As a result, my lord, my case was dismissed. And finding of the case is 118, the order on the basis of elaborate discussion about issues, the appreciation of materials available, or it appears that the plaintiff failed to prove norms of the herself to her family members being defamed by way of adducing cogent evidence that on the relief as well as keeping herself within the torture of the Evidence Act. I have exhibited all the certified copy, all the documents.
Okay.
And in view of that, my lord, the impugn order required to be interfered with, my lord. Because no issue, no discussion, no specific issue was framed. Why I asked for the damage? And simply it has written, my lord, whether malicious defamation, number 4, my lord, what plaintiff is entitled for the 4 and 5. That has not been discussed. In view of the issue number 3, my lord, entire case has gone, my lord. And from the pleading, it reveals, my lord, I asked for the damage. I did not file anything specifically malicious prosecution. As I have stated, because of the role played by the police, my name and fame has been destroyed in the society. Paragraph 16, 17 my lord, in the plaint is there. And more vital is that, my lord, there had to have, my lord, some discussion in the issue number 4 and 5, not, my lord, copy paste, my lord. Applying the judicial mind, my lord. Had it been taken into account, my lord, the 4 and 5, there would have been something. But it has not been discussed or not taken into account. The trial court was issue number 4, my lord, simply they said, my lord, page 117, my lord. In so far the relief claim by the plaintiff concerned the elaborate discussion made in the third issue. Because of the third issue, 4-5, according to the trial court, has not been taken into account. Page 117. The entitled to, and simply said, my lord, issue number 5, what relief is entitled for? In view of the discussion made above, appreciation of evidence on record, it gets reflected that no additional refute is warranted in the from the side of the court to the parties given in the set of circumstances. Meaning thereby, because of the issue number 3, 4, 5 was not taken into account.
Yes.
Only that much, my lord. In view of that, my lord, the impugn order required to be set aside, my lord, because the issue, specific issue as per the plaint has not been framed.
Issue regarding
Issue regarding, my lord, damage.
on account of
On account of, my lord, para 16, on account of, my lord, the misuse of police power. Para 16 and
okay. Yes, anything else?
16 and, my lord, 21, my lord. Lordship will see, my lord, the while seeing, my lord, Lordship, I like to request, my lord, without killing time of the court, my lord, Lordship will see the list of document, my lord, 12, 13, 14. And all the documents, whatever I have submitted in the PWs, my lord, it is there in the record in original, which I have obtained certified copy. Only that much, my lord, in view of the case, my lord, is required to be adjudicated on the ground of the damage as per the plaint.
Yes.
Certificate copy to me. May I take back?
Yes.
the certificate?
Into return for it.
My lord, only, my lord, after replying, my lord, if situation warrants, my lord, I may be permitted short reply, if.
Yes. Yes, Mr. Dao.
This is a story of love, betray, and frustration, madam. Outcome of this suit. Why I'm telling so. The London trial court has also said there's something not divulged in the judgment, my lord. The materials on record, the SMS, all produced before the court. SMS in between the parties. And those SMS cannot
By
be
both sides.
by both sides, and much more than this plaintiff. And the entire suit she has admitted that suit has CS filed to restore the relationship. I will come to that. But the opening remarks of this case, my lord, on behalf of the respondent is, this is a story of love, betray, and frustration. Why I am saying so, my lord, the lordship is fine that the lordship query I am first answered. What is this suit is, in fact, the lordship is fine in paragraph 16. She said that the plaintiff said that she defamed. Now she has been defamed before whom? And the London trial court comes to a finding that the defamation by herself, does not constitute to be a defamation unless it's supported by some other witnesses before whom she was defamed. There was no evidence in record.
Okay.
Who, stands before the court to say that yes, the defamation by herself, does not constitute to be a defamation unless it's supported by some other witnesses before whom she was defamed. There was no evidence in record. Who stands before the court to say that yes, the defamation by herself, does not constitute to be a defamation unless it's supported by some other witnesses before whom she was defamed. for such search, seizure, we were witnessing the facts in the house. And in our opinion, her image was lost. There was no single witnesses in the case. Now, Lordship, I'm just pointed out some facts before entering into this issue. There's multiple litigations in between these two parties, commencing from 2011. First, she lost an affair, which was registered on 2nd of November 2011 by the CID, being CID case number 95 of 2011.
Alleging what?
Alleging that she was, her modesty was outraged, she was blackmailed, and she was, out of this blackmailing, she surrendered to this defendant. Basically, that allegation was there. And that FIR comes from by a final report by the CID on 8/10/2014. That is Exhibit 13 below. That is exhibited as Exhibit 13. And another FIR this defendant has lost, that on 30th August 2011, upon which the Karimganj PS case number 483 of 2011 was registered. And this FIR also comes to finally ended with a final report on 11/10/2014, that is Exhibit 12, which my learned friend also referred. Now, first, this plaintiff appellant has challenged the Karimganj FIR before this Honorable High Court.
Second affair.
Quashing the FIR.
Second one or first?
The FIR of Karimganj PS.
2011.
Yes, no, this is the FIR by the plaintiff.
Okay.
There's a CID case.
Okay.
Now, she has filed a question application against the FIR lodged by the defendant at Karimganj. When the Karimganj, the defendant was an SP, holding the post of Subordinate Police. So, he approached this Honorable Court for quashing that FIR. Now, the Honorable High Court has directed to conduct the investigation, both the case amalgamated and conducted by the CID. Then against that order, he went to Supreme Court. Supreme Court in an interim order says that it has to be investigated by a superior officer than the defendant. They did above the SP level. So therefore, both the case investigated by a DIG level officer, which both the case ended with a final report, which I referred.
Okay.
Then, while the Supreme Court case was pending before the matter is pending before the Supreme Court, then the final report was submitted. Meanwhile, after that, the Supreme Court finally disposed the entire matter, saying that giving a liberty to file your protest petition, take an appropriate step before the concerned court. Then this plaintiff has filed a protest petition before the London CGM at Kamrup Metro of that CID case 95, which she was the informant. The London CGM Kamrup rejected her protest petition and accepted the final report. Then the plaintiff again challenged that order before this Honorable Court. That's an important. And that the Honorable High Court in a criminal petition number 33 of 2016, which was exhibited as Exhibit A by the defendant side through the plaintiff during the cross-examination. And by this criminal division petition, the Honorable High Court has rejected her application of criminal division petition and accepted. Finally, the final report was attained the final. And Meanwhile, in 2016, in 2015, the plaintiff has filed the suit. In the suit, in paragraph 16,
But the criminal case was not pursued. Any
thereafter, then against
complaint.
this order of the Honorable High Court of this criminal revision petition number 33 of 2016, which rejected the plaintiff's challenge of that final report of our case.
Yes.
She went to Supreme Court. But Supreme Court did not interfere finally.
Okay.
So therefore, the acceptance of the final report of her case and our case become final. That's the background. Now, she has filed this suit before the civil judge Dibrugarh, wherein Lordship is find that in the prayer portion, there is no declaration whether the
Why damages is to be granted.
yes, there is no declaration. There's a vague prayer, in fact, that she claimed for a general damage. Whether it's arising out of the malicious prosecution or it is a defamation. So therefore, thereby the foundation of the suit is itself. Though the London trial court says that it is mentionable, but since it is a first appellate court, my lord can also take into account of this issue. Now, just to answer the query of this honorable court, in paragraph 16 of the plaint,
yes,
she said plaintiff has said some damages. But in contrary, in paragraph 19 and 20 of the plaint, the plaintiff says it's a case of malicious prosecution. No, she will kindly comes to paragraph 19. Already 16, my lord has already my learned friend has taken this honorable court to paragraph 16. 19.
Yes.
From the above, it would therefore show, page 44.
Yes.
It would therefore show that the defendant had maliciously tarnished the reputation, goodwill, and image of the plaintiff by filing a false and frivolous complaint against the plaintiff. This false and frivolous allegation made in the first information report dated such and such have lowered the reputation of the plaintiff in every share of their The false and frivolous prosecution initiated at the behest of the defendant has traumatized the plaintiff since their knowledge of filing of the complaint such and till such and such. The spirit of trauma felt the same and humiliation faced the exploitation such and such, such and such. So therefore the suit. Now the London trial court correctly, because we argued before the London trial court saying that how it can be said to be a prosecution, as this Honorable Court also make it clear. The prosecution has to be there. Prosecuted the accused. Now there was no prosecution or persecution because he is ended at the bar. The FIR was ended with the final report. So there was no scope of any. And in the final report, in both the final report, there was no statement by the investigation officer. This is a false case. The basic in online, if we say this is a 5-page, 6-page this report. The one in online, if your lordship is asked me to analyze what the report about the case. In online, the report is saying that it's a relationship, it's a acquiescence of the parties. Both the parties are in relation. And it was not disputed. So everything has been come up with that frustration. When the defendant has stopped from taking call from the plaintiff, not responding the SMS, then the frustration goes. Then it stirs and all disputes stirs. Even, my lord, the plaintiff has wrote a letter to, after the affair of 2011, sending numerous SMS to the plaintiff, to the defendant, and also wrote a letter to his mother, whereby saying that please restore our relationship. And whose relationship? After 26 years of marriage, of having two sons, my lord.
This thing was never brought to.
No, I will come. I'm calling. They all, everything on the evidence, my lord. Everything on the evidence. Everything on the evidence. I'm not disturbing my friends. Everything on the, I'm not saying anything out of the evidence. Thousands of SMS he has sent during this period. Therefore, the final report says, is out of this frustration, all the affairs has been lost. The final report questioned how the plaintiff, how the informant say, alleging modesty, outrage of modesty. By that allegation, leveled against a person, and you thereafter, you continuously contacted, may make a contact and send ambassador to the defendant to restore the relationship. It is also an admitted fact in the evidence. So this is the background of the entire case. Now, Lordship will find that the issue number 3 is a composite issue, my lord. It says whether defendant maliciously prosecuted, because this is pleading, paragraph 19 and 20, maliciously prosecuted the plaintiff under Karimganj PS case number 483, page 86, 2011, causing damages to a reputation. So it's a connected issue, my lord. If prosecuted, if it is found that is a prosecution, then causing damage. If it is not found that is not prosecution, the question of damage would not come. And because the malicious prosecution not defined in the court, so therefore the learned trial court take advantage from taking the definition from well-recognized books. There is a Black Law Dictionary and Halsbury. The judges also take help of the Halsbury, my lord. Halsbury is a precious collection of a chamberlain. But a day to very difficult to purchase, my lord. It's a big amount, my lord. Very difficult to purchase. But Dibrugarh Bar has in the library, in the Dibrugarh Bar library, there is a Halsbury laws over there. And perhaps the learned judge has taken the help of that. Because the judge's library of the district court, Lordship will not find the Halsbury laws over. And also taking the help of the Black's Law Dictionary. It is not own invention, as my learned friend says. It's a well-recognized book, well-acclaimed book in the judicial system, judicial fraternity. And taking the definition of what the prosecution is, the learned trial court came to a finding that there is no prosecution. So therefore, there cannot be said to be a malicious. Now, my lord, the trial court has discussed the evidence. It is not a fact, as my learned friend says. Now she will find in the judgment, in page number 111, my lord, in 5 paragraphs, is commenced from 10.35 to 10.39. Page 111. The learned trial court in detail, my lord can take a note that in page 111, it starts from paragraph 10.35 to 10.39. 10.35 to 10.39 in 5 paragraphs, analyze the entire evidence and came to a reasonable and justified conclusion.
Yes.
I'm just showing one because it's a 5 paragraphs. I will not, Lordship may go through, but I'm only, Lordship will find in page 112, para number 10.37. Before that, all the evidence the London Trial Court discussed. Now 10.37, the London Trial Court has discussed the judgment of our High Court in respect of the defamation suit. And the High Court judgment says, my lord, what the 10.37 referred to, that unless you defame before third party, it's not a defamation. It is a normal concept and normal, it's a general prevalence, my lord, principles. Now, Lordship, kindly have a look at the clear findings of the London Trial Court, 10.37, last 4 lines, page 113. I'm reading
Yes.
from,
Yeah.
moreover, it is submitted. Lordship,
Yes.
moreover, it is submitted that the plaintiff's own opinion about herself cannot be called as reputation, and henceforth the plea raised by the plaintiff is non-sustainable from the viewpoint of law. Because there is no evidence on record. The PW to who? Her husband. And he has said, my lord, the husband said, in his presence, the defendant has visited numbers of times in his house and spent time with the plaintiff. That's the evidence. PW3, one of the drivers who accompanied her to the police guest house. That's the evidence. And 4 is all these pen drives, these mobile phones, everything has been sent to Truth Laboratory. And the expert came and deposed. I will come to that one. So this is the findings of the court, and these 5 paragraphs, long 5 paragraphs, analyzed all the evidence of this from 10.35 to 10.39. The evidence of the on record, the documents, and came to findings that the plaintiff has miserably failed to prove the factum of her loss of reputation and causing damage to her goodwill or reputation in the society. And it is a fact, my lord, materials of record is admitted by the plaintiff that she made publication in the newspaper, not by the defendant. She made a statement before the news channel regarding her case. So the entire acts of the plaintiff shows that she, in fact, by her conduct and acts, defamed herself and lowered down the prestige of the family along with the grown-up children by the acts of herself. Now, Lordship, kindly have a look at I'm just cross-examination. 4 days she was cross-examined in the court. And sometime, my lord, sometime she said, she cried. Why she was crying, my lord? She was crying to restore the relationship. And once when the defendant refused, then
that I object, my lord. There is no evidence to that effect.
I will come. My
Husband, they have not given anything, my
I-
lord. Out
yeah.
of court, my lord, he is making story.
My
Let them show the record.
learned perhaps I don't know what the reason, not read out or place before this court the cross-examination part of the plaintiff. So I am here to assist this honorable court. So therefore, it is my duty to read out the evidence cross-examination of the plaintiff.
PW1.
PW1, my lord. Lordship, kindly, the record is with the court, my lord.
C1 files.
PW1.
One fact, my lord, I am just telling. This is the additional affidavit the plaintiff has filed. What happened?
Where?
In the
Trial court.
Trial court. What happened? She herself went to, with a summon of the court, to serve, while the defendant was SP of Dhubri. She herself went to his residence at night.
Dusty service.
Dusty service, my lord,
There
in
is
night.
order.
Night. And thereafter, she again lodged an affair against the constables, against the guard of the SP, against the SP. And Dhubri PS case was registered. And that was also filed by additional evidence. That everything is not evidence. Now, Lordship will kindly have a look at first cross-examination of PW1 on 2nd day of June 2018. See, like,
Itu kar. Itu loyo. Rosona PW.
A file, B file, C1 file, my lord, it's all
not
matters relates to the trial court.
Yes. Cross-examination.
Yes, of PW1, my lord, on 2nd day of June 2018. I am sorry, my lord, I have one copy only.
Okay, you read slowly. If you're good.
Right.
Reads.
Yes, ma'am. Now, I have just skipped the first cross-examination because all this is a cross-examination relates to that this statement has not made in the affidavit. Now, I am on the second page of the cross-examination. May I read?
Yes, please read.
I do not remember when I intimated about the incident to my husband, but it is obviously prior to 19/5/2011. I was married with my husband, Sri Dharani Barduloi, on 16/10/1983. Therefore, I am saying 26 years. I am having two sons, namely Sri Ankur Barduloi, aged about 30 years, and Srimati Akanksha Barduloi, aged about 26 years. On 10/5/2009, the first physical relationship occurred with the defendant and then continued till 21/7/2010. How it is defamation case, my lord? Extramarital affairs. I first met the defendant in the month of November 2008. It is not a fact that it was an incident of love at the first sight. On 10/9/2010, this is important. On 10/9/2010, I wrote a letter addressing the defendant, and the contents was, quote, I feel for you with my soul, so my feelings for you will die with me, not before that. So that was the feelings, my lord, of the friend towards me. Then the witness explained. He then said, explanation, I was persuaded by the IGP to write such a letter. Lordship, kindly have a look. Then, my lord, there is a note by the court. The witness was asked about the correctness of the contents, such as, quote, মই জীৱনত এবাৰেই নিজে সম্পৰ্ক পাতিছো, হেয়া অকল তোমাৰ লগত জীয়াই থকা লৈকে ভাল পাই থাকিম, বাট চাই থাকিম. This is a poetry, my lord.
So there was a relationship.
Yes. So what I am stressing, my lord, then she sent this ambassador after she admitted, my lord. I sent Dipanjali Dotto, advocate. He hired an advocate, my lord. I sent Dipanjali Dotto to the defendant in the month of August 2010. I gave her a letter of authority to talk on behalf of me regarding the issues.
I wrote 2 numbers of letter to the mother of the defendant in the year 2012. Then 2012 means, my lord, 2000 after the affair. After the affair, she wrote a letter to her mother. 2012, asking her to search out the ways to settle the matter amicably outside the court by playing a neutral role. I also sought for justice without harming the defendant. I know the Azhar dated 19/5/2011 lodged by me against the defendant ended in final report and accepted by the Chief Judicial Magistrate Kamrup Gauhati. I challenge the acceptance of the above final report before the Honorable Gauhati High Court by Criminal Revision Petition number 33 of 2016. And on 17/5/2018, the Honorable Gauhati High Court dismissed the revision in the final report marked at Exhibit 13 in para number 3, second part, it is mentioned, quote, the communication between the complainant and the affair named Ali's accused person continued over phone, mostly at the behest of the complainant, that is the plaintiff. Sometime later, the alleged affair named accused person suddenly discontinued/declined to receive phone calls of the complainant and stopped responding to her SMS. But the complainant continued to send SMS from her mobile and other mobile phones to the mobile phones of the other accused person. The complainant made all possible attempts to restore the earlier relationship, unquote. That is the finding of the final report. Now, this is the first day cross-examination. On the second day, my lord, on first day of September, she was cross-examined. Married.
Yes.
In between the period of 22/3/2009 to 10/5/2009, I met the defendant 2 times. Thereafter, we met several times, and lastly on 21/7/2010 at my residence at Dibrugarh. During that time, I did not disallow him to enter my residence. I expressed my annoyance to the defendant during our meetings from such and such. I can show the proof in the call data reports submitted before this court. On 21/10/2010 from such and such, I have sent 6-7 numbers of SMS to the defendant. During this period, I sent more than 1,000 SMS. She admitted, my lord, 1,000 SMS to the defendant. He also sent SMS to me during this period. After about 1 month of filing of criminal case against the defendant by me on 19/5/2011, the defendant stopped keeping such communication with me. By the term to sort out the matter mentioned in line 5 of page number 3 of Exhibit 7, I intended to mean amicable settlement of everything what happened with him. That is her affair, my lord, Exhibit 7. The term suffering in line number 3 of para 2 of Exhibit 7 means the traumatic condition suffered by me. The defendant threatened me verbally, but I have no documentary proof to substantiate the same. I stand by with the SMS serial number 89 such and such as appearing in page number 19 of Exhibit 1. The SMS number serial number 33 of page number such and such. As I was having no intention to talk with him, I sent Advocate Srimati Dipanjali Dotto with an authorization letter in the month of August 2010 to meet the defendant at Tinshukia to sort out the matter in consultation with me. It is not a fact that the defendant declined to talk with me. I sent a letter to him asking to restore the relationship with me. Admitted. Exhibit A is the certified copy of the judgment dated 17/5/2018 passed by the Honorable Gauhati High Court in CRP number 33 of 2016. Then she said, I do not concede with the contents of paragraph number 35 of the above judgment. I prefer an appeal before the Honorable Supreme Court of India against the judgment. Now, we ended the cross-examination on the second day. Then on the third day, my lord, on 18th day of September, my husband came to know about the relationship with the defendant in the month of July 2010. After being informed by me, many times I met with the defendant in my residence at the absence of the members of my family, except 2 times when my husband was available. Even in the presence of the husband, my lord, the plaintiff met with the defendant. I do not remember as to how many times I met with the defendant. It may be 5, 6 times. I mentioned sending letters, 30th 8, 2010, handwritten 10/9/2010, and another letter to the defendant and his mother in my protest petition dated such and such, filed before the learned CGM Kamrup Metro, challenging the final report such and such. On 11/12/2015, the learned CGM Kamrup rejected my protest petition and accepted the final reports, aforesaid. On 27/3/2009, I went to Tingshukia for my official duty, such and such. This is all general question, my lord. Then in the middle part of the cross-examination, I want to highlight. In the final report, Exhibit 13, the IO mentioned, quote, the statement of witnesses cited by the complainant also does not support the allegation brought. Thus, on discussion on the evidence collected, the allegation brought by the complainant has been found to be fabricated, concocted, or non-believable. In my Karimganj PIS, there was no statement, my lord, that I filed a false case. But in her FIR, my lord, there is a clear findings of the investigation officer that her FIR is fabricated, concocted, and not believable. Rather, I would like to file, it is my duty to file on the defamation suit.
This FR is by IGP.
Yes, yes, the directed by the Honorable Supreme Court. There is Exhibit 13, madam. It is not a fact that the final report marked Exhibit 13 at page 3, main report such and such, under objection such and such. Now, the last part of the cross-examination of that page, more than 1,000 SMS were sent by me to the defendant from 8/6/2011, that is after the FIR, to 2/6, because the FIR she said 19/5, to 2/6/2012. Through those SMS, I attempted to settle the matter amicably with the defendant. So it's a case of acquiescence. It's a case of relationships. And it is a case of, my lord, out of frustration. Now on the, thereafter, my lord, I skipped the other parts. The next page, my lord, page number 2 of the cross-examination. It may be 3, my lord. This may be 3. The middle part, my lord. I came to know, I came to know that the defendant as complainant lodged a complaint against me on 29/10/2011. It is not a fact that after having information of the case filed against me by the defendant, I lodged the FIR against him. Now, this is important. I gave interview with the news channels, namely News Live and DUI 365 after 29/10/2011. I do not remember the exact date. Some news items were also published in some newspaper. I stored the same in my pen drive. So this is admission. She published everything. It's not me, my lord. I handed over the pen drive to the IO of the CID case and same was analyzed by the FSL during investigation. I made conversation with the defendant after filing of the complaint to the DGP Assam. In the final report, although it is written about threat perception, etc., I deny stoutly. It is a fact, it is the important part, my lord. It is a fact that during the conversation with the defendant, sometimes I cried and fought over conversation. My learned friend has denied this. Raised his protest, my lord, but this is a record. His client has admitted that she was cried sometime. She was fight with the defendant sometimes, my lord. All out of frustration. It is not a fact, such and such, skip this. I never said anywhere that the relationship with the defendant was a merely acquiescence or friendship. It is not a fact that in my plaint in para number 4, I have stated that my relationship with the defendant is not merely acquiescence or friendship. This is the admitted part, my lord. In the paragraph 4 of the plaint, she said that is more than acquiescence and relationship, my lord. In para 4 of the plaint. It is not a fact, such and such, my lord. Now, the last cross-examination, my lord. On 5th day of January 2019. I've just
Yes.
made it.
I filed the instance suit. Now he said, my lord, I filed the instance suit alleging defamation as well as malicious prosecution. I filed a suit both for getting compensation.
Where she's saying?
First line, my lord. 5th day of January 2019. Last cross examination. On 5th day of January 2019.
The 8th day.
5th day of January 2019, my lord.
PW4, sir. PW1, sir.
PW1.
That part is okay.
For convenience, my lord, we will also have a Xerox and give it better.
You have to give point-wise written gist of your submission.
Fine.
You may also do so.
My lord, we will submit.
Okay.
We'll submit, and I'll also the certified copy of the this cross examination.
On which you are relying.
Which with all 4 days.
All certificate copy I got also.
Yes.
What is there in the last cross
Yes,
examination?
yes. Last cross examination. First 2 lines, my lord.
Yes.
First, it starts the process. I filed the instance suit alleging defamation as well as malicious prosecution. I filed the both suit, both for getting compensation as well as for settling the issues between me with the defendant. That's the main issue. The final report in Karimganj PS case number such and such submitted by the IO stating insufficient evidence was accepted by the Nanak CGM Karimganj Assam. Now this is important, my lord. Although I am defamed by the action of the defendant, I did not mention before whom I was so defamed, either my plaint or in evidence. So how could it to be said to be a defamatory statement?
This aspect was taken into consideration in the impugned judgment.
Yes, absolutely correct. Absolutely. In five paragraphs. I did not mention the basis on which I have calculated the amount of compensation either in the plaint or in the evidence. On 29/10/2011, the police authorities visited my residence at Dibrugarh in connection with investigation of Karimganj PS case number such and such. And I also cooperated with the same. Nothing wrong, my lord. Cooperated the same. The defendant initiated the proceeding against me at Karimganj and not in Dibrugarh. This doesn't relevant, my lord. This is the only question of the territorial jurisdiction. I am not present. So this altogether the cross-examination of PW1. Now PW2 is the husband. If addition PW2 or 3.
Sometime be given to me, my lord. I have
appellant. Also, Mr. B. Dutta, Learned Senior Counsel, assisted by Mr. S. Degar, Learned Counsel for the respondent. Hearing concluded. However, Learned Counsel for both sides are requested to submit a written gist of their respective arguments on when.
The plaintiff, he's got privilege, my lord.
July.
Well,
31st July, list accordingly.
we need to give copy.
To the court master. It will be again listed on that day.
Well,
matter will be listed on that day. You submit your directly to the court master. List accordingly.
Copy to the Anai court.
This lordship, item number 28. Last item.
28?
Eight.
Yes.
Lordship also that.
All my cases are being mentioned, Lordship.
Maybe sixth
So
of another-
other cases, can I leave?
6th of August.
No, we will not give. When,
The date is being
item number 28.
28 he's saying, but he is for a respondent, Lordship. Claimant advocate, I do not know. They might have some. And,
Maybe 20th or 6th of August, ma'am.
and they have not given me copy also,
6th of
Lordship, of the
Yeah.
cross
In the
objection.
meantime, I will inform that you have the.
Already order is there, they have not given.
Heard Ms. Adi Majumdar, learned counsel for the appellant. Also heard Mr. Asif Paul, learned counsel for the respondent. Number 3, who prays for an adjournment. The prayer is allowed. Let this matter be listed on 6th of August.
They file an process objection furnished to the applicant.
The order is already there.
Already there,
I'm
but
not repeating.
Not in, but I got.
Learned counsel for the
he's
appellant.
given 2.
Learned counsel for the appellant submits that in spite of specific direction by this court, the appellant, the respondent/claimant side has not furnished the copy of memo of cross objection along with annexures to her. The appellant, the respondent/claimant are directed to comply with the directions of this court before the next date fix. List according.
Highly apply.
আধা পাঠ দেখা হয়ে আছে না লিস্টিং দিব আৰু এটা আছে নামাৰ পিছত ডিসকাস
Item 12.
Yes, my lord.
Yes, Mr. Bhattacharya.
Yes. My lord, the seizure list is exhibit 57, page 79.
Trial court records. Page.
Page 79 is the seizure list.
Yes.
So by what? Seizure.
Whether it mentions the vehicle number.
My lord. Yes, it is mentioned. Vehicle number is mentioned in the seizure list. And my lord, in the MVI report also, that is exhibit 58, page 80. Vehicle number is there, and your lordship will.
What is the vehicle number?
Vehicle number is given, my lord, AS06L0142. And your lordship will MBI report also stated that there's a damage in the bumper. Your lordship will find in the column number, below the column number 11, my lord. On his examination, he found that there's a damage in the bumper. Your lordship got it, my lord.
MBA report is page 80.
Page 80, my lord. That is the MBI report.
Yes.
The cause of the action, damage due to the accident, bumper. Lordship got it.
Yes.
So from the seizure list, as well as from the charge sheet which is filed against the driver, and my lord, MBI report, it clearly shows the name of the driver as well as the vehicle number. Because, my lord, this is the 2 grounds, my lord, which the learned trial court did not take into consideration.
Whether this number, vehicle
Yes.
number tallies with the policy.
Yes.
Insurance policy.
Yes. My lord, even if a lordship comes to the cross of the DW1, that is the insurance company's survey, my lord, the page 42. Page 42 of the record, my lord. DW2. for insurance company. Lordship got it, my lord? He has given the evidence, and in the cross, what he has stated, my lord.
Just a minute. Anup. I'm taking a short break.
Short break.
Short break.
Oh, lordship, lordship. Oh, so I'll give you, my lord.
Yes.
The DW one of the evidence. We cross him, my lord. He is the surveyor. Your lordship got it, my lord.
Yes.
In the cross, I have submitted the report before the insurance company. I did not know whether the insurance company has filed the same before the court. I met the owner and the driver of the vehicle. The charge sheet is filed against the driver of the offending vehicle. In connection with the Digboy PS case number 136, the charge sheet is found without submitting the registration number of the offending vehicle, but the name of the driver is found in toto with the materials of record. However, the driver of the vehicle was mentioned in the column made against the name of the accused in the charge sheet. The MBI report and the seizure list mentioned the vehicle number, registration of the vehicle number. The company has not challenged the genuinity of the charge sheet submitted by the police. So he also admitted that insurance also admitted that MBI report was there. Then seizure list was there where the vehicles numbers are mentioned, my lord.
Okay.
And the PW2 also, my lord, categorically stated the vehicle number, but the insurance company has not crossed him to that line. PW2 PW2 base photo. Base to level.
Yes.
Even in the PW2 also, my lord, in the evidence, my lord, he has categorically stated the vehicle number. That is not rebutted by the insurance company, my lord, in the clause.
Vehicle number is, repeat again.
My lord,
Repeat the vehicle number.
pending vehicle number AS01L 06L oblique 0142.
Okay.
No,
Okay.
this is no.
Well, what was the age of the deceased at the time of his death?
Age of the victim, my lord.
Yes. This is a death case.
Death case, my lord. He was a government servant. Death certificate. Next. Death certificate. Postmortem death certificate, my lord. Exhibit 3, page 52. That comes to my lord. Date of birth is that is death certificate. No.
What was his age?
I'm coming, my lord. Just. Is up to you know. Regulation to court. He was 49, my lord. No, the claimant, no. The claimant was deceased. 49.
Claimant was 49.
Claimant was 49. Disease was 42.
Must be some higher age.
Limitation to put that. I'm just finding it. Limitation to it.
Can go through the evidence.
Limitation to that. Limitation. It was 49. 49. In the claim petition, it is there, age of the person injured 49.
Yeah.
Postmortem also. Postmortem report to you. Postmortem report is. As per the postmortem report, it is 50, my lord. That is exhibit 2, page 51.
Date of birth is 1/11/1966. Date of birth. 1/11/1966.
There's a photo. So another report, how you will see.
P3.
Yes, what else is your submission?
My lord, these are the two grounds. On this basis, my lord, I'll submit a one latest Supreme Court judgment of 25, my lord. Your lordship will go through the paragraph 6, 8, my lord, 9, and lastly, my lord, analysis and conclusion, that is paragraph 60 and 17.
What it says?
It says if in the MBI report is there and charge sheet is there and scissor list is there, then it is deemed to be the accident of that car. Whether it is immaterial, whether in the FIR it is there or not.
Where read out that.
Yes, my
portion.
lord. We have bestowed the anxious consideration of this. At first glance, the odd seem evenly placed. Both the sides have raised the arguable issue, but as it may, this court is touched upon the balance of law with the actual position. Moreover, in the present case, when the real fact position may not be clearly discernible due to the various factors, this court leaves the court to adopt the practical view that was emerged in the deposition of the witness. The very fact of the case was registered against unknown vehicle initially would indicate that the offending vehicle was not identified. However, since an FIR is not expected to be an encyclopedia, it is only the purpose of putting into motion the criminal law such that although the full-fledged investigation by the police ensure, it is the duty of the investigation to find out the identity of the culprit, in which the present case would be of offending vehicle and the driver taken action against according to law. Thus, the mere fact that initially the FIR recorded the vehicle was unknown would not be fatal for the prosecution claimant to come up with the specific identity of the vehicle owner with the obvious caveat that connection of the accident with the said vehicle has to be based on the cogent and reliable evidence. In the present case, the factor of the favor of the insurance company is that the conduct of the supposed eyewitness, who was the consumer in the pawn shop, gives his statement to the police about the 2.5 months after the accident, disclosing the registration number of the vehicle. That these raise serious doubts over the authenticity thereof. It has to be noted in one piece of the paper that when he again visited the spot after 15 days, he came to know the injured had passed away. Even after the lapse of the said 15 days, he neither informed the pawn shop owner nor produced or hand over the sheet of the paper to the police to which he claims the registration number of the offending vehicle was noted. PW2 in his evidence to effect that he went to the pawn shop about 2.5 years and found the police inquiring about the incident. When ultimately he disclosed his knowledge of offending vehicle and his registration number is taken, if something more is that, at least a pinch of salt. Additionally, the fact that the claim proceeding before the MSCT, the pawn shop owner was not cited as a witness, also raised a doubt for the reason and the connection of the consumer to the pawn shop was only through the pawn shop and without pawn shop owners testifying. The witness who claimed to have noted the number was a customer at his shop. The so-called customer eyewitness may not be able to pass the test of reality, especially in the wake of the background of facts and the carcass. However, on the other hand, a person has died and the police, upon investigation, submit the charge sheet against the driver of the Varna car. There is available on record this inspection report dated 21/6/11 prepared by the MBI inspector, which is available on the record, disclose the bend of the front mudguard side of the bumper of the car indicate that it represents something, which would have been the scooter of the deceased. The MSCT award was personal liability jointly and severally. That is the next paragraph 21. The court is left with no option but to presume that the owner of the vehicle offending who caused the accident had no defense to offer before any of the three fora, including the court. However, it transferred from the record that during the police investigation, when the owner of the vehicle was confronted with the telephone driver, he was the police version admitted the accident in question was occurred. So the MBI report and the seizure list, my lord, is important here. And I will also rely upon one Tripura judgment, my lord. It is 2018, my lord. Paragraph 14. Here, my lord, this about the FIR, MBI report, all has been discussed, my lord, in reference to the Supreme Court, my lord. The 14, 15, 17. Where it is said that MBI report as well as the seizure list is enough, my lord. And the charge sheet where the driver has been named.
No, in the instant case, in the charge sheet, there is.
Driver name is there. Vehicle number was not there.
So it is not clear which vehicle he was driving.
But in the MBI report and the seizure list, the vehicle number was there.
Okay. MBI report is submitted in the criminal case.
My lord, they have submitted charge sheet against the driver.
In the along with the charge sheet.
Yes. It is clearly covered by those decisions, my lord. The same facts of the case, my lord. And the Supreme Court relied on the charge sheet, on the MBI report and there's in Mangalram cases also there, my lord. And then another decision, my lord.
No. So many decisions is
yes, my lord.
not necessary.
In 2021, my lord.
What else is your submission? Suppose we believe that vehicle is involved. The vehicle of whose registration number is mentioned in the seizure list is involved.
Yes.
Then what will be your submission?
If the vehicle number is
vehicle which you are indicating is involved in the accident.
Yes.
Then what will be your submission?
My submission that I am entitled for the compensation.
How much?
My lord, as per the calculation I have given him.
The appeal you have already calculated. Appeal memo.
I have in the appeal memo, I have given. I have already given.
In the appeal memo here.
Yes.
Okay.
Page number 6, my lord. In the appeal memo, page number 6.
Yes, yes, Mr. Burman.
Lordship.
Lordship, may I place a brief of my written argument?
Yes,
If
yes.
Lordship permits, so that it can apprise the honorable court. What points I will argue in coming to the case. Lordship, here is a case where my learned senior has now placing reliance on the MVI reported a seizure list. Now they are trying to say that this particular vehicle was actually involved in the accident. And they are also relying on a statement testimony of an eyewitness. Now, Lordship, my question is, where the police found this vehicle? Where is the entry? Where is the basis? How this vehicle came into play? There must be some GD entry, Lordship. How this vehicle was found? Whether it was found during investigation, whether driver had surrendered before the police, when he had surrendered, or when police, at what time police found this vehicle. There must be some GD entry. As per police manual, Lordship, as per Assam Police Act, Lordship, there must be a GD entry, GD diary entry.
No,
which should be entered.
even if there is no GD entry,
How can we believe
in the case diary there,
Lordship,
because vehicle was seized.
Lordship, there must be some explanation how police came to know about this involvement of the vehicle, because owner and driver was not in the trial. They didn't appear, Lordship, and the claimant side did nothing to call them as a witness.
So that will be.
They could have stated that actually, yes, our vehicle is actually involved. This is my first question, Lordship. Secondly, Lordship, here, this case was role of the police was very doubtful, as rightly observed by the trial court, Lordship, and that's why this claim petition was dismissed, Lordship, being a doubtful case. And we are really relying on this GD entry FIR, Lordship, and Lordship here, the police itself destroyed this case of the claim. I'm coming to that. We have called the investigating officer as a DW in this case, and his evidence completely destroyed the case of the police. It is very doubtful how police has investigated this case, because your Lordship, it's a case under section 166, it's third party claims, Lordship. There must be some nation negligent right. Yeah, as per section 279, there must be some reason. Supreme Court says in 166 cases, proof of negligence is a sine qua non. The Lordship knows. Now, Lordship, I'm coming to my submissions. What I have written in my I'm coming to one by. I'm not going details of this judgment, Lordship. I am just pointing out a particular points whose the learned trial court has observed in our favor, Lordship. First of all, Lordship, I have already stated that there is no any other merits in this appeal, Lordship, in spite of that the submission made by the learned senior, Lordship. And Lordship, you could see, Lordship, this judgment was based entirely and thoroughly considering all the evidences which were brought before this tribunal, and this was properly appreciated by the honorable member. And after applying the judicial mind, Lordship, the weight was in favor of our side, and that's why this case was dismissed, Lordship, because all the evidences were brought before this honorable court. Not only the police report, witnesses we have brought in defense, Lordship. Now, Lordship, I would like to specify what are the points that has been discussed by the learned member MSCT in passing this judgment, Lordship. First of all, in para 11 of the judgment, Lordship, I would like to come. Yes. Para 11.
Yes.
Now, from the merit, Lordship.
Yes.
Now, from having perused the evidence of witnesses together with the documents so submitted, it appears that a vehicular accident took place on 14/8/2016 at about so and so in front of the office so and so. A pedestrian was found to have sustained injury followed by his death in the hospital. The evidence as it appears to go so that when the deceased
Dhaniram Gogoi, along with others, were walking after coming out from the office by the left side of the road. Then the unknown vehicle dashed away Dhaniram Gogoi from backside, causing serious injuries to him. Lordship, here unknown vehicle was involved, and the GD entry proofs, Lordship. The initial GD entry proofs in the entry were entered by the police.
No, GD
It says
entry
a
was
Indigo
on,
vehicle.
GD entry was on the basis of the
Yes,
FIR.
but-
FIR.
But Lordship, some information was definitely received by the police.
So the informant was not knowing have not noted the number of the vehicle.
In the affair, unknown Indica car.
Yes.
No vehicle number was mentioned there.
Yes, that we are accepting that
Yes.
informant failed.
That the trial court has observed.
Thereafter, subs.
Then Lordship, para number 13. Para number 13, Lordship. It is specific defense of the opposite insurance company that GD entry was entered by the police on the very day of the accident reveals that the deceased Dhaniram Gogoi was dashed away by an unknown Indica vehicle. But the number of the vehicle could not be ascertained and it was fled away from the place of occurrence. Subsequent GD entered, there is a subsequent GD also entered on the same day, do not mention anything about the Maruti Swift, the alleged offending vehicle. The affair was filed with the wife of the deceased on 18/8/2016, even showing that after 4 days, this affair was lost. Showing that her husband, while was coming from duty along with colleagues, while we were working, just by an unknown vehicle causing serious injuries. This is the observation based on the evidence brought on record. The Honorable Trial Court has put in the specific para. Now in para number 15, Lordship. Para number 15, Lordship, in the last para, merit. Interestingly, nothing is there to show this in the search sheet as to how and under what manner the investigation was conducted by the police, and to show the involvement of the driver in the respect of the vehicle that caused the occurrence on the very day. The name of the owner of the vehicle was not mentioned in the search sheet. And Lordship, in the claim petition also, the person who was arrested as a owner, Lordship, no details were given there that he is the actual owner. Also, there is nothing to show that the driver, Sanjeev Gogoi, was the driver of the vehicle of the Swift bearing so and so, so and so. So the existing material on record, it is found insufficient to hold the view of the vehicle number so and so, that is offended vehicle, was involved in this case, and it was driven by the driver, Sanjeev Gogoi, at the relevant point of time, Lordship. Then next para, Lordship. Interestingly, claimant has not mentioned the owner of the vehicle. They have not mentioned the owner of the vehicle in the claim petition, Lordship. Although one middle go was found to have been added as OP number 2, but nothing is there to show as to what at what capacity he was made as OP in this case. So claim petition was itself defective, Lordship. Considering this all aspect, I am of the view that plea taken by the insurance company that there is a strong suspicion as well as discrepancy errors in formulating the case has got substance. So accordingly, this case has been dismissed. So my points of argument, Lordship, I will then refer to the LCR. I have gone to the LCR, Lordship. I will refer to the particular pages of the LCR where I will give stress in my argument and rely on this the evidence, Lordship. First of all, Lordship, as I said, already I have said in my earlier submission that FIR filed by the applicant claimant that an unknown vehicle hit her husband, which is available in para number 46 of the LCR. That is the FIR.
Yes.
Again, Lordship, interested the FIR form mentioned FIR form that is entered by the police. The FIR form mentioned about an unknown Indica. That is page number 45 of the LCR. Then again, Lordship, GD entry number 438 dated 14/8/2016 has also mentioned about an unknown Indica car. which is available at page number 43 of the LCA.
Yes.
So, Lordship, initially this Indica car was there. Everyone has stated the prima facie case was found against the Indica car, which eventually fled away. Now, how this Maruti Swift car came into play, I don't know. What material is available in the record that Maruti car was actually involved, how it was traced, how it was found the driver was actually driving the vehicle. Where is the material here, your Lordship? Whether any investigation was done, whether any supplementary search sheet was filed, whether this search sheet mentioned about, explains about these things, how the investigation of
No, but your own witness,
yes, Lordship.
DW2,
Lordship.
DW2, who,
Lordship. Witness is there. There is a witness, but that can be taken to Lordship. Police finds anyone who can make such a witness in the search sheet, Lordship.
no, whether insurance company adduced any
Lordship.
evidence.
Then I'm coming. Then DW1, we have adduced a defense
Your
evidence.
own investigator.
Yes, DW1.
DW2, DW1.
DW1, Lordship. He confirmed that GD entries number, these were exhibited 438 and 440 dated 14/8/16. He stated that unknown Indica vehicle was reported on the date of accident. This was confirmed by him. Again, in this regard, Lordship, nothing rebuttal evidence was or cross-examination was done by the claimant that this Indica car was not involved and the Maruti was no specific any document or any such material was brought. This is page numbers 27 and 30 of the LCA Lordship. That very important in this case. I'm relying on this evidence entirely. This is the very vital evidence of DW2, who was the investigating officer of Digboy PS. He stated, Lordship, this is page number 30 of the LCR. He stated that as per GD entry number 438, an information was entered at about 10:10 p.m. on 14/8/2016, stating that one unknown Indica vehicle had dashed the deceased. He further stated that he did not personally investigate the case. He did not have any personal knowledge. This was the statement of the investigating person. Yes, he did not have any personal knowledge, and this was not rebutted, Lords. So we had done our part. That actually an Indica car was there, which is fled away, Lords. Because we are relying on the GD entry FIR. And the evidence of the police also did not say anything. This is our case, Lordship. My humble submission is that, Lordship, even though MBA report severely says there about this particular offending vehicle, but what was the basis of bringing this vehicle into this particular case? How this vehicle came into play? Was there any note by the officer in the search sheet or any GD entry there that I found this vehicle on such and such day? I have recorded a statement and a GD entry was entered. Or whether the driver has surrendered before me.
Once investigation is initiated, every time GD entry need not to be made.
But
after investigation,
would be there.
After investigation, any finding of fact has to be there in the case diary.
But Lordship,
regarding seizure, the endorsement has to be in the case diary of the case.
What I'm on, Lordship, this is a case of bringing in one vehicle after reporting of the FIR against some other vehicle, and later on police has found another vehicle. There must be something to explain, Lordship. And in search sheet also nothing has been elaborately explained. So how can a court can believe in the story of the claimant merely on the two documents? In my humble submission, Lordship, this is a good case, Lordship, and there is no interference or required, Lordship, by this honorable court. As Lordship, because there is no perversity in this judgment. There is no material irregularity or error committed by the tribunal, Lordship, and I am relying on some decision. My learned pen has, senior has placed some decision. Lordship, I'm also placing some decision in support of my case. Lordship, I'm having reliance on 4 decisions, Lordship. I am placing. I have already very short decisions. I'll not take much time. 2 High Court decisions and 2 Supreme Court decisions, Lordship. And just read out just particular paras, Lordship. Lordship, in serial number 1.
Tripura High Court. Yeah.
Lordship, serial number 1, I have placed one decision of Tripura High Court, which are fits in my case. Relevant para is para number 14 and 15, where it is stated, Lordship. I'm relying on para number 14 and 15 and 16 also. I have already marked. What the Honorable Court has observed. At the same time, the police officer should not willingly join with the claimants and others to satisfy the facts of the case only with a view to fasten the liability on insurance companies. Most of the insurance companies in India are public sector insurance companies, and they are trustees of public money. The manner in which liability has been shifted on insurance companies shows total dishonesty by police and other officials. At the same time, I must commend the fire service official who did not sense their record. In view of the above discussion, I am clearly of the view that the accident occurred with truck number so-and-so and not with bus number so-and-so. Therefore, the appeal is allowed and impugned award of the learned tribunal is set aside. Then para number 16. Copy of the judgment shall be sent to the judgment was sent to the Director General of Police, who said ensure that this sort of occurrence does not take place in future. He shall not ensure that police officers are instructed not to sense the facts of the case, thus to switch some individuals. This is para number 16. That is direction given to the DCP, Lordship. Then next decision, Lordship, this is serial number 2, a Supreme Court decision, Lordship. Surendra Kumar Arora, SCC 552/2012. Here I am relying on para number 9 and 10. May I read? Para number 9 and 10. Admittedly, the petition filed by the claimants was under section 166 and not under 163A. This is not in dispute. Therefore, it was entirely responsibility of the parents of the deceased to have established that respondent number 1 drove the vehicle in a rash and negligent manner, which resulted in fatal accident. Maybe in order to help the respondent number 1, the claimant has not taken up that plea before the tribunal. Therefore, the High Court was justified in sustaining the judgment and order passed by the tribunal. We make it clear that claimants had filed the petition under 166 here, then dicta of this court in case of so-and-so would come to assistance of the claimant. In our view, the issue that we have raised in our consideration is squarely covered by the decision of this court in case of Oriental Insurance Company, Tupra. In the said decision, court stated, therefore, the victim of an accident or his dependent have an option either to proceed under sections 166 or 163. Once they approach the tribunal under 166, here is a case of 166. They have necessarily to take themselves the burden of establishing the negligence of the driver or the owner of the vehicle concerned. But if they proceed under section 163, it is not required. Here is a case of where the Honorable Court has observed the rash and negligent driving is must. Then Lordship, Panwarlal judgment, serial number 3, Lordship, this is Rajasthan High Court judgment, Lordship. I'm just relying on para 4 only, Lordship. Here the Honorable High Court, while stating that failure to prove the involvement of the specific vehicle in a motor accident can lead to the rejection of claim for compensation, had observed that though the appellant has also relied upon the search sheet filed with the police against the driver of the vehicle, here in this case same facts, the tribunal has observed that as per a law laid down by this Honorable by this court in case of Sunita versus Hanuman Singh, reported in 2011 CCR to 305 Rasta. Same cannot be treated as a conclusive proof of involvement of the vehicle number so and so so. Then again, Supreme Court judgment last I have number 4 where I have relied. The proofs of dress and negligence, which is pair number 10, Lordship. This is my judgments I have relied, Lordship. So, Lordship, in most particularly, I will point out the driver and the owner will not have contesting party in this case. So, it is not clear whether the vehicle was involved. The claimant should have called them. It was a burden of the claimant because they were made as a party. They did not contest this case.
No, they did not contest. Therefore, the inquiry proceeded ex parte.
Yes, boss. But they could have been called as an witness to prove these facts. If they have said that yes, this vehicle was involved, then nothing to do.
Just small submission, Mike. Small submission.
Yes.
Well, the cross of the DW1, the insurance company's witness, my lord. He had met the owner. He has met the driver. He has admitted, and he also stated the company has not
He
challenged.
is the insurance company's investigator.
Yes, he has been examined by them, and he stated in this clause that company has not challenged the genuinity of the charge sheet submitted by the police. Now, how he can raise the question now, my lord? It is they who said.
No, Sashi has already been
No.
contested by the
Your
we have
witness has
created a
said.
doubt, Lordship.
Your
Doubt was readily created. How can we bring
your witness has said it
whether
is not made in
there
the
was a
cross.
supplementary charge sheet?
How can you deny that?
No
He has
supplementary
stated in
charge
his evidence that we have not challenged the charge sheet. How can you deny that? Your own evidence.
Heard Mr. K. Bhattacharjee, learned counsel for the appellant. Also heard Mr. P. J. Burman, the learned counsel for respondent number 3 and 4.
3 and 4.
3 and 4 / insurance companies. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellants / claimants, namely 1 Padma Gogoi Bora, 2 Rup Jyoti Gogoi, and 3 Borish Gogoi, impugning the judgment and order dated 9/5/2019 passed by the Motor Accident Claims Tribunal number 3 Kamrup Metro, Gauhati in MAC case number 2174/2016, whereby the claim filed by the present appellants under section 166 of MV Act seeking compensation for death of the husband of claimant number 1, late Haniram Gogoi, was dismissed. Stop. The gist of accusation. The facts relevant for consideration of the instant appeal, instant MAC appeal, in brief, are that the on 14/8/2016 at about 9 p.m. when the husband of the claimant number 1, namely late Thaniram Gogoi, was returning going by the side of the road on foot. He was hit by unknown vehicle, as a result of which he sustained injuries on his person and later on succumbed to the same. After the said accident, the claimant number 1 lodged an FIR before the officer in charge of where the FIR was lodged.
14.8, I suppose. If you have FIR on 14.8%. Date of accident was 14.
Yeah.
Page number FIR.
FIR on,
No.
page number
Okay,
18,
please stop.
I have already,
Please stop, please.
Lodged an FIR before.
I'm finding out. Fine, sure. FIR, I think it's page number 46, 46 of the LCR.
So please do that.
14.8, 16 and 18.8, I think the FIR lost.
Before the officer in charge of Bigburg Police Station.
FIR loss will find.
Stop.
Page number 46.
On the basis of the said FIR, Bigburg PS case number 136/2016 under section 279/338 of the Indian Penal Code was registered and investigation was initiated. So later on, the present appellant approached the motor accident claims tribunal number 3, Kamrup Metro, Gauhati, by filing an application under section 166 of the MV Act 1988, seeking compensation for the death of their husband/father in the aforesaid vehicular accident. Stop. The said, on the basis of said application, MAC case number 2174/2016 was registered. The driver and owner of the offending vehicle did not contest the claim of the present appellants/claimants, and the inquiry proceeded ex parte against them. However, the insurance company contested the claim of the present applicants and filed a written statement. Issues were not framed.
Particular issues framed regarding.
On perusal of the records of the MAC case number 2174/2016, it appears that no specific issues or point of determination was formulated by the Motor Accident Claims Tribunal in the aforesaid MAC case. However, by judgment and order dated 9/5/2019, which has been impugned in this appeal, the claim case of the present appellants was dismissed on the ground that the claimant have failed to satisfactorily show that Maruti Swift bearing registration number AS0106L 0142 was involved in the case and was involved in the accident and the death of the husband slash father of the claimants occurred due to rash and negligent driving of the said vehicle. Stop. Mr. K. Bhattacharjee, the learned counsel for the claimants, has submitted that the trial court erred in dismissing the claim case filed by the present appellant, ignoring the materials available on record. He submits that though the FIR filed by the claimant number 1 was the informant also.
Yes, yes.
First informant.
Yes, ma'am.
FIR filed by the claimant number 1 did not mention about the registration number of the offending vehicle. However, later on, during the course of the investigation, the offending vehicle was seized as apparent from the seizure list in the connected criminal case. He submits that the seizure list, which is exhibited as Exhibit 5 within bracket 7, as well as the MVI report, which is exhibited as Exhibit 4 within bracket 6, within bracket 8, clearly mentions about the registration number of the offending vehicle as AS06L 0142. He submits that, therefore, the trial court has, therefore, the Motor Accident Claims Tribunal has erred in dismissing the claim of the present appellants merely on the ground that in the first information report as well as in the charge sheet, the mention of the registration number of the offending vehicle is not there. He submits that the mere fact that initially the FIR records the offending vehicle as unknown would not be fatal for the prosecution if later on the identity of the said vehicle is known during the course of investigation. He submits that in the instant case, apart from the seizure list within bracket Exhibit 5 within bracket 7 and the MVI report within bracket Exhibit 5 within bracket 8, the testimony of PW2, who was one of the eyewitness, clearly indicates the registration number of offending vehicle as AS06L0142. He further submits that even the witness of the insurance company name, that is the investigator who was examined as DW2,
DW1.
DW1 has deposed in his testimony that he met the owner of the offending vehicle and the registration number of the offending vehicle has been mentioned in the MVI report as well as in the seizure list. He submits that the tribunal erred in ignoring the evidence of DW1 while coming to the finding that while raising suspicion about involvement of the offending vehicle, involvement of vehicle bearing registration number AS06L0142 as the vehicle causing the accident and resultantly the death of the father slash husband of the present husband slash father of the present claimant, present appellants. He submits that the DW2 has categorically deposed in his testimony, though the charge sheet has not mentioned the name of the registration number of the offending vehicle. However, name of the driver of the offending vehicle has been mentioned categorically in the charge sheet as accused, and which tallies with the materials on record. Dot, dot, dot. I'll dictate remaining portion in chamber. You have given your written submission. I have taken notes also. Heard Mr. K. Bhattacharjee, learned counsel for the appellant. Also heard Mr. P.J. Burman, learned counsel for the respondent insurance company. Hearing concluded, judgment reserved.
All right, sir.
Okay. All right.
Otherwise also
There's
time is
paucity of time.
due to paucity of time we may not.
My lord, it's an old matter, my lord. I just pray that if a short date may be granted. 24 matter, it's a covered matter. I just pray that a short date may be granted in this matter.
First week of August.
My lord, I'm grateful.
I heard Mr. D. Rathi, learned counsel for the appellant, also heard Mr. C.K.S. Borra, learned standing counsel, learned central government counsel. Due to paucity of time, this matter could not be taken up today. List this matter in 4th of August.
Much obliged.
Remaining matters, it will be difficult to, instead of calling all the matters, because no time is left.
Any date may fix in the month of August.
It may be fixed now in regard to item number 35.
That I leave on considering our board code diary. You take those who want specific dates may take dates from the court master. Otherwise, the matters would be shown as leftover. Registry will list it accordingly. But if you want a specific date from court master, you can take it.